My lord's kind leave to mention a very urgent application to move with unlisted. My lord, authorities affixed a notice saying that they will dispose me today. The appropriate forum available in law is vacant. The charge is not there. I have
Granted.
My lord, may I move 2 p.m.
My lord, under compelling circumstances, I'm troubling your lordship. My lord, this matter pertains to Andaman Port Blair Circuit Bench, my lord. My lord, I've heard this matter before. My lord was pleased to set aside the delistment order. Despite setting aside the delistment order, my lord, they are now not letting me participate in any of the tenders, my lord. My lord, one of the tenders at which I have participated later on by a letter, they have said that...
When is the next Port Blair bench?
My lord, it's going to start from Monday, but they are going to open the financial bit tomorrow, my lord.
No.
My lord, kindly, my lord.
No, you could have moved it earlier. No, not now.
My lord, we have come to know on the last Friday, my lord.
No,
We have fixed the... My lord,
Yes.
My lord, may I have your lordship leave to mention item number 85. My lord, the permission for Ganesh Puja, my lord, is being turned down.
What? Rightly.
ADDA committee.
You will perform Ganesh Puja? Rightly turned on for Lord Ganesh. No, Mr. Ganguly, you won't be permitted to.
My lord, kindly see the rejections. My lord, 3 lines I will be reading for your lordship. They are permitting, my lord, Durga Puja to be conducted, but my lord, Ganesh Puja, they are not interested.
That much discretion the authorities
Yes,
have.
because it
will never end.
Because it is the vice chairman's puja, my lord.
No. Every puja is vice chairman. Either this vice chairman or that president. Somebody. Either you will be the president of something and he will be the vice chairman.
2014, my lord, we are, my lord,
This cannot be open. A floodgate cannot be opened like
this. Is not a floodgate, my lord. 2014, my lord.
Tomorrow you will perform Itu Puja like this on the streets. No. I don't have anything against Lord Ganesh. Definitely not. But Mr. Ganguly, no. This is not an urgency.
The urgency from 18th, my lord, this is going to be held.
They must have some discretion.
No, my lord,
You will perform a puja, you want a puja.
see the rejection.
What? Read it out.
My lord, henceforth, the permission for using the said open space, that is the, my lord, land, my lord, shall be restricted only for conducting.
It's appearing as item 85.
85.
Kalke tope diye debe. Yes.
This is the matter for non-prosecution, Milord. Dispute regarding the issue has already been settled, Milord.
Handover, it's appearing in the list.
No. It's
to be
not
mentioned
appearing.
is non-prosecution.
Yes.
For upgradation, Mala, this petition filed on 21st December 2022. Item was 775. My lord, the damage, my lord, petitioner's shop was damaged due to fault of Metro Railway. Thereafter, petitioner lodged the written complaint. And
no upgradation.
24%, my lord.
No upgradation, please. Yes.
My lord, may I be permitted to mention a matter for non-prosecution, Your Lordship?
Handover. Do you mention non-prosecution? Call.
I will say day list item number 1 for judgment.
Accordingly, WPA 25668 of 2022 is allowed, thereby setting aside the lookout circulars issued against the petitioners and restraining the respondent authorities from preventing the petitioners from traveling abroad in any manner on the strength of the said quashed LOCs. Respondent authorities shall immediately arrange for communication of this order and the fact of the LOCs having been quashed by causing necessary publication of the same and intimating about the same to all authorities who are intimated about the LOCs in the first place, to ensure that the petitioners are not restrained unduly from leaving the country on the basis of the quashed LOCs. No orders to cause administrative.
Your Lordship, in this matter, I'd like to mention something.
Yes.
As per instruction of the DSG, sir, he has asked for a stay on the operation of the order for 2 weeks, just for 2 weeks, Your Lordship. In the meantime, we'll move for it.
Very well. You are for?
For SFIO. Yes, Your Lordship.
At this juncture, an order of stay is prayed for. Full stop. In view of the nature of the order, stay of operation of the same is granted for a fortnight to enable the SFIO to prefer a challenge against this order. This will be a part of that order.
Item number 2.
Well, 2 non-prosecution, I have a written instruction with, right, I am for the petition.
The petitioner submits that the petitioner does not want to proceed further with the matter. Puts up a written instruction in that regard, filed by learned counsel for the petitioner, be kept on record. Puts up WPA 14646 within bracket W of 2019 is, accordingly, dismissed for non-prosecution without any orders to cost. Interim order, if any, stands vacated.
Grateful. Grateful.
এটা না এটা বলে দিতে পাঠিয়ে দেবে, কিন্তু এটা এখন কিন্তু হবে না। স্টে অর্ডারটা ঢুকে তারপর এটা যেন আপলোড করে। হ্যাঁ। Yes.
Item number 3,
Lordship, item number 3, your lordship, this is not my matter, your lordship. Yesterday I've mentioned WPA 1374 of 2023 of the circuit bench. Now this is appearing, your lordship. What has happened, if I may say in a line, your lordship, this matter an vacating application was preferred. Thereafter,
Jalpaiguri circuit.
Jalpaiguri circuit bench matter. And now they have brought this CAN application before this bench so that it could be listed. Neither it is listed before your lordship, neither the file is there in the circuit bench. I have mentioned twice before the present circuit bench there.
Should it be transmitted to that the regular bench?
Lordship.
না কিন্তু এটা তো লিস্টে নেই, আজকে অর্ডার দিতে পারবো না তো। ওটা টু বি মেনশন আনতেই হবে কালকে, ওনার কাছ থেকে নিয়ে নাও স্লিপটা। দিস ইজ দ্য প্রপার, দ্য আইটেম নাম্বার ইজ দ্য সেম।
Lordship, item number is একবার দেখান।
আইটেম নাম্বারটা তাহলে সার্কিট বেঞ্চ বলে মেনশন করে রিকুইজিশনটা করতে হবে কালকে টু বি মেনশন। দিস উইল অ্যাপিয়ার এজ টু বি মেনশন। আইল পাস অ্যান অর্ডার। The oh yes, you are appearing.
Your lordship, this matter is item number 36032 is item number. I am the advocate on record, but petitioner did not want to continue with me, so I just want
No,
to tell-
petitioner probably mentioned a different matter, so
Yes.
I'll let this matter go out of the list.
Yes, deeply obliged, your lordship.
Since the present writ application is appearing erroneously in the list, comma, as another writ petition of the same number but pertaining to the Jalpaiguri circuit bench was mentioned. So accordingly, let this matter go out of the list. Full stop. The matter mentioned by learned counsel for the petitioner in the Jalpaiguri matter be listed tomorrow under the same heading. Let it appear tomorrow. I'll pass whatever order. Yes.
Deeply obliged, your lordship.
Thank you. Yes.
item number 4,
But item number 4, I appear on behalf of the private respondent, the writ application.
The petitioner is appearing in person. My lord, she had called me up to inform.
Petitioner mentioned the matter.
Petitioner mentioned the matter. In person, she is appearing. Yesterday, she mentioned the matter.
Right.
My lord, she's stuck up in a jam. Therefore, she wanted me to pray before my lord for a short passage.
Why have you got any idea why she mentioned the matter for?
Well, probably I can give you some,
I am not in the matter.
I can give you some idea. my lord.
Yes, yes.
In the writ petition was filed, it's a husband and wife dispute, my lord.
Oh,
Now, my lord, the writ petition was filed seeking certain direction, my lord, on the husband, who is the respondent number 2, my lord, for making certain payment on account of dues for purchasing a property. Now, my lord, otherwise, I think, my lord, probably the writ application is maintainable if the EMI is not paid, the scope and avenue is open under Securitization Act, if lordship sees the relief. However, my lord, when I appeared on behalf of the private respondent and matter appeared before Justice BHATTACHARYA, my lord, I submitted before the court that it can be sorted out amicably. I tried, my lord, but it didn't work out. But the last order was passed by Justice BHATTACHARYA, my lord. Lordship would find, my lord, on 11th of May, holding that probably this is a fit case for mediation. I did not, my lord, dispute. Petitioner also, lordship would find, appeared in person, my lord, though an learned advocate was engaged, did not dispute. If lordship sees the order, I think this is a fit case, my lord, for sending the mediation. AFCONs have been referred to, my lord. I have no dispute. Though I have filed a suit, my lord, I was dispossessed one after another
so then
complaints.
can you please keep any of your learned juniors when the lady comes? I'll
Yes,
wait
yes.
for say 10-15 minutes. If it is called on within that, if she does not come, I'll put it tomorrow. If she comes, then I'll pass this order. I'll refer this to mediation. Then.
My lord, only thing, my lord.
But let it be in her presence.
Yes, yes, certainly, my lord. Otherwise, the
Otherwise, complications.
Yes,
will arise.
but only thing, instead of, my lord, after 10-15, lordship takes it up, my lord, after 12, lordship court rises at 12.
Very well. I'll go back. I'll go down and come back. When I come back, I'll take up this matter.
I think that
Unless some other matter is going on, after
yes,
that,
yes,
I'll take up.
after that we will be
Very well.
I'm
After
grateful,
12.
my lord. I'm
After
grateful.
এটা 12টার পর আমি একবার 12টায় উঠি, ফিরে এসে তারপর নেবো।
Grateful, my lord.
Thank you. Yes.
item number 5,
I am for petition, lordship.
Yes.
My lord, I am for the respondent 2, 3 and 4.
Right.
My lord, we have complaint.
My lord, without interest, my lord, I have received the all year pension, my lord, family pension. From 2013, my lord.
Oh, they've already very. Then I'll dispose of.
My lord, without interest, they have not paid any interest. 2013, my lord.
What
I
was
have
the
no
matter?
widow, my lord.
My lord, it is regarding the payment of arrears pension. We are the disbursing authority. On
Right.
the last occasion, we received the letter.
Why did you delay so much? I mean, your client?
No, my lord, we have received the instruction on 16th August 2023 on the last occasion.
Instruction from whom?
Instruction from the Indian Audit and Accounts Department.
Oh,
That-
so you are not at fault, you are saying.
Yes, my lord.
My lord, I am appearing for the Indian Auditor Accounts.
You are appealing for the?
Principal Accounts, Office of the Principal Accountant.
Yes, why did you delay so much?
My lord, we received it only on 28th of July, my lord,
Receipt from whom?
from the disbursing authority.
You are the disbursing authority.
Yes, my lord.
So they say you received only, they received
My
only.
lord, kindly consider, until and unless we get the instruction, how can we pay?
Instruction from which authority?
Instruction of we are the sanction authority. They are the sanction
The
authority.
very first paragraph is
They are the sanction authority.
No, no interest. The pensionary dues have been disbursed by the bank. A document in that regard is handed over in court today and is kept on record. Next para. That counsel for the petitioner submits that the petitioner has had to wait for quite a long time, and as such, interest may also be granted on the amount. Upon hearing learned counsel appearing for the disbursing authority stroke bank, as well as respondent number, you are for 6.
Yes.
As well as respondent number 6, it cannot be ascertained without a fact-finding inquiry as to as to who was liable for the delay occasion. Next para. Be that as it may, since the petitioner's prayer has been substantially satisfied, there is no need to keep the writ petition pending. In any event, such fact-finding inquiry to fix liability being not possible by the writ court, the question of interest is not being gone into. Accordingly, WPA 17219 of 2023 is disposed of as infructuous in view of the payment of the pensionary dues having already been made to the petition.
I'm good.
অনিন্দিতার কাছ থেকে টিপস নিয়ে কোনো ব্যাপারে কোনো yes.
Item number 6.
Yes, Mr. Kormakar.
The plaintiff lord is the petitioner of the lordship lord in a suit for declaration, lord, that the plaintiff is a lord legal occupier of the suit premises and lord for injunction. Now, lord, the revisional application is directed against an order, lord, allowing Lord Order 6 Rule 17 filed by the defendants.
It's an assigned matter.
Assigned.
Achha, very well. Yes.
Lord, filed
It
by
took some time to orient actually. Yes, from writ matters to so very well. You are the plaintiff. You filed an Order 6 Rule 17 rejected.
I am the plaintiff, suit for Lord declaration that I am a legal occupier of the suit premises and for injunction. Revision is directed against an Order 6 Rule 17, allowing Lord the defendant to file amended written statement.
Counterclaim.
No, Lord, at a stage, Lord, they say that it's an explanation of a paragraph, but Lord, I say that has been done.
At what stage?
At a stage when my 3 witnesses are complete, he has tendered his Lord the evidence in chief.
Show me the amendment.
My lord, kindly, Lord, comes to WS, the amended WS at page 18, and the relevant Lord paragraph your lordship would find that the amended
No, this
26. I'm sorry, Lord, not 18. It's 26.
Right.
20. I'm sorry. The relevant portion is Lord 27.
Yes.
12A. That's the last paragraph.
Right. 12A is the only amendment sought.
This is the only amendment sought. ঠিক আছে, একই জিনিস আলাদা করে দেখা
Yes, they have clarified.
Lord, I
The
would say-
devolution has been more elaborately stated.
Lord, first of all, Lord, this was known to them. Lord, the proviso is hit. There is no explanation given by Lord the learned trial judge, Lord, with respect to due diligence. Why they could not bring this on record, or Lord, kindly sees the amendment application once, page 66. And this has come up at a stage, Lord, when I have completed my evidence. Page 66, Lord, Lordship kindly got it, Lord.
Yes.
Para number 3 is the only explanation. After pursuing the averment made in paragraph number such and such of the written statement, it is detected that the defendants have claimed to have acquired the property from their said such and such. However, source of acquisition of such and has not been disclosed in details. As a matter of fact, when acquired such and such, the lease deed Lord, thereafter is gold. And no explanation why he could not produce. Lord, I would make this submission with your Lordship, Lord. Had it been a case, Lord, prior to the trial, things would have been different. This everything, all facts were known to him. It's not a fact that, Lord, they have subsequently come to discover about these documents and all. It's a mandate.
They have stuck to their case. Their case is they received from Bhagwat Singh.
Counterclaim. There is no counter.
No, they have stuck to their case in the sense they said initially also para 12 that they acquired from Bhagwat Singh.
Yes.
So they have stuck to that. They have just given the details.
Lord, that
even if they did not give the details, they could have.
Lord, I would say this amendment in that score is not necessary. Is that in that on that score is not necessary. Lord, all amendments, the ground, Lord, that has been given by in the impugned order, Lord, kindly turns to the impugned order, Lord. That is only no prejudice will be caused to me. Decision with reasons, Lord, on perusal of proposed amendment, the written objection, written statement, it appears that the foundation of very proposed amendment has been laid down at the time of drafting such and such. No way tends to nature and character. Lord, that apart, it is settled principle of law that the court should be more regular in allowing amendments of the written statement comparison to the
Your grand senior laid down the law.
Hello?
Your grand senior laid down the law on this regarding written statements. It has to be more liberal. Justice Tarun Chatterjee, while in Supreme Court.
Lord, subsequently,
Mr. Aniruddha Chatterjee, his father.
Perhaps,
so your chamber laid down the law.
Perhaps not the law has a bit not
show me that is
modified.
That will be interesting. Yes.
Lord, 2019 5 SCC 360.
Any particular
This is
paragraph?
a very short judgment, Lord. May I place? It's a 2-page judgment.
Definitely, yes.
The appeal involves a short point of disposal such and such. The appellants are proposed defendants, whereby, Lord, the nature of amendment. What I intend to show your Lordship, Lord, is paragraph 9. In our view, the trial court was right in rejecting the application. This we say for more than one reason. First, it was wholly belated. Second, as per now, plaintiff filed the application for amendment of the plain when the trial in this was almost over and the case was fixed for final arguments. And third, the suit could still be decided even without there being any necessity to seek any amendment. Lord, I'll be harping on this. Lord, there is no counterclaim. The issues that is required to be, Lord, decided does not, Lord, require this amendment to be gone into. So, Lord, that's wholly unnecessary. That's the first, Lord, point. The other is copy to that. Copy to that. Lord, the second.
Yes.
1 minute. Lord, this is 2020 11 SCC 549. This is also, my Lord, a very short judgment. This is just to
Yes.
This is just to indicate, Lord, that if it is hit by proviso of section order 6 rule 17,
right,
then, my Lord, it's a mandate on the trial judge, Lord, to arrive at a finding that there was a due diligence exercised, and despite exercise, Lord, they could not have. Paragraph 7. In the present case, the civil judge has not returned any finding that the court is satisfied that in spite of due diligence, the party could not have raised the matter before the commencement of trial. In such and such, this court observed, it is the primal duty of the court to decide as to whether such an amendment is necessary to decide the real dispute between the parties. Only if such a condition is fulfilled, amendment is to be allowed. However, proviso appended to Order 6 Rule 17 restricts the power of the court. It puts an embargo on exercise of its jurisdiction. The court's jurisdiction in a case of this nature is limited. Thus, unless the jurisdictional fact as envisaged therein is found to be existing, the court will have no jurisdiction at all to allow the amendment of the plaintiff. Here the written statement. Similar, there is no finding. Only finding is there is no prejudice that will be caused. That in my respectful submission cannot be a ground for allowing amendment. These are my respectful submissions.
Yes, for this.
My lord, only two submissions, my lord.
Now, which was the page of the amendment application? I'm sorry.
Page 65.
65.
60.
Right. Yes.
66. 66, my lord.
It's all the same. Yes.
My learned friend, my lord, has come up with two objections, my lord. First, my lord, there is no explanation in my application for amendment. That's his first objection. The second, my lord, is that, my lord, the amendment is wholly unnecessary. But he concedes, my lord, that it is really, my lord, an explanation to my defense, which I've already made on in my written statement. But in my respectful submission, there is some explanation. Whatever it is worth it, my lord kindly takes my amendment application at paragraph, my lord, 5 at page 67. Although, my lord, the name of an advocate has been mentioned, my lord, it's our case before the court, my lord. We were entrusted the matter to an advocate, a senior advocate. He drafted it. We filed it, my lord. My lord, this is one, my lord. So it's
no
not that
warrant of due diligence.
There's no warrant of due diligence, my lord. We were wholly reliant on someone, my lord.
So it's not your lack of due diligence.
My lord. My lord, that's one, my lord. Whatever it's worth it, my lord, my duty to place on record, my lord.
Yes.
One. Second, my lord, my learned friend says, my lord, since it's already an explanation, this is not required, my lord. The evidence, my lord, in support of my title is not. My lord, all that I say, my lord, at this stage of written statement, I have to plead my case. And unless I plead, my lord, I will not be able to lead evidence in support thereof, my lord. But I have, my lord, pleaded, my lord, in my original written statement that this is how I have the title, my lord. Here, my lord, I want to elaborate and place on record the title deeds, my lord. That is all that I intend to do, my lord. Now, my lord, kindly takes the order impugned, my lord. The explanation given, my lord. My learned friend, my lord, had read a part of it, but I want to show two more portions of the order impugned. Page 62, my lord, decision with reasons, my lord.
Yes.
My lord, though, my lord, fifth line, though in our case, the amendment application has been preferred after the initiation of the trial, but in spite of that, it appears that the sad facts which have been sought to be incorporated with defendant are important for proper adjudication of the matter in dispute. That's the finding of the court below, my lord. The court finds that, yes, it may be required for proper adjudication. And then, my lord, 5 lines from the bottom, my lord, 6 lines from the bottom, here in the background of the instant suit, it appears that the amendments sought are for, if allowed, the other side will not be prejudiced. But as the said amendment petition has been filed at the stage of PW evidence, it is duty of this court to compensate the defendant. That apart, after trial amendment must be allowed with cost. Advocate for the plaintiff has argued that as the instant amendment has been preferred after conclusion of the PW evidence, if the same is allowed, the plaintiff will not be able to controvert the facts in the pleading, as unlike defendant, they do not have a chance to file any additional.
Why 700 rupee cost? Because it was filed after 7 years.
Right. On this, I'll bow down.
You need to clarify on that.
But this cannot be the sole reasons to reject the proposed amendment, as because the time of cross-examination of the DW, the plaintiff shall have sufficient opportunity to cross-examine the defendant on the newly amended facts.
Pay cost of 10 times of that.
I'll bow down. I'll bow down. Kindly allows me. I'm deeply obliged.
Learned counsel, for the petitioner contents that the impugned order, allowing an amendment of the written statement filed by the defendant stroke opposite party was passed without jurisdiction. First up, it is contended that the proviso to Order 6 Rule 17 of the Code of Civil Procedure, as amended, clearly stipulates that if an amendment is filed at the stage of trial, the court has to record its satisfaction that despite due diligence, the party seeking the amendment could not have brought it earlier. For some next para, in the absence of any explanation in the application for amendment and in the order impugned, it is argued that such proviso has not been satisfied in the present case. First up, apart from there being no explanation for the inordinate delay, particularly since the evidence of the plaintiffs has been closed, comma, it is also argued by the petitioner that the amendment was wholly unnecessary, comma, even if it is construed that its foundation was present in the written statement. Full stop. Next para. Learned counsel for the petitioner cites two judgments, comma, the first in the case of Pandit Malhari Mahale, naam dekhe kore diye, reported at 2020 11 SCC 549, and the second such and such reported at 2019 5 SCC 360. Full stop. Next para. Learned counsel for the plaintiff stroke opposite party argues that a semblance of a reason has been given by way of explanation for the delay in the amendment application and places reliance on paragraph number 5 of the amendment application in support of such contention. Full stop. Moreover, comma, it is contended that the learned trial judge, while deciding the issue, comma, took into consideration that the facts sought to be incorporated are important for the proper adjudication of the matter in dispute, and that the amendments sought, comma, if allowed, comma, would not prejudice the other side. Full stop. Next para. Insofar as the argument that the amendment sought is unnecessary, comma, it is argued that the said amendment, comma, unless brought on record, comma, would not furnish details to the original arguments made in the written statement, and it would be difficult for the opposite part, plaintiff stroke opposite, defendant stroke, it would be difficult for the, you are the defendant, I'm
Yes,
sorry. It will be difficult for the defendant to lead evidence on the original pleadings. To some next para. A perusal of the judgment cited by the petitioner shows that the Supreme Court has consistently placed reliance on the proviso to Order 6 Rule 17, full stop, in Vijay H. Shah Supra, comma, the Supreme Court observed that the trial court therein was right in rejecting the amendment application for three reasons, full stop. First, comma, it was wholly belated, comma, second, that the plaintiff filed the amendment application when the trial of the suit was almost over and the case was fixed for final arguments, and third, comma, the suit could still be decided even without any necessity to seek amendment in the plaint. Puts up next para. Insofar as the first logic is concerned, comma, in the present case, comma, we have to keep in mind that the present revision has been filed not against an order rejecting an amendment, but one by which an amendment has been allowed. Full stop. It has been consistently held by courts that even after the coming into force of the proviso to Order 6 Rule 17, comma, that courts are generally liberal in granting amendments, comma, if the same is necessary for proper and complete adjudication of a suit. Full stop. Next para. In the present case, comma, the trial judge rightly observed that the amendment sought to be incorporated is important for the proper adjudication of the matter in dispute. Full stop. Next para. The defendant is also justified in contending that in the event the details of the transactions are not mentioned specifically in the plaint, comma, in the written statement, comma, it might be difficult and complicated for the defendant to lead evidence on such transactions at the juncture when the defendant is called upon to lead evidence. To some next para. As to the second point referred by the Supreme Court in Vijay H. Shah Supra, comma, in the present case, comma, the suit is not fixed for final arguments, but the defendant's evidence is still open. Full stop. In any event, comma, it will be open to the plaintiff stroke petitioner to examine the witnesses of the defendant in cross-examination, and, comma, as such, comma, the plaintiff cannot be said to be in much prejudice if the amendment is allowed. Full stop. Moreover, comma, if need be, comma, the plaintiff can also recall its witness, comma, if so required to deal with the amended pleadings. Full stop. Next para, the third ground of the Supreme Court is also not applicable herein, comma, since the amendment, comma, although may not be of utmost importance for the suit, comma, would definitely lead to a proper and complete adjudication of the disputes in controversy between the parties. First of next para. Insofar as Pandit Malhari Mahale Supra is concerned, comma, the Supreme Court in the said case observed that the civil judge had not returned any finding that the court was satisfied that in spite of due diligence, the party could not have raised the matter before the commencement of trial. Full stop. However, comma, the decision was not restricted to such finding alone. Full stop. Next para. The court went on to observe, comma, by quoting a judgment of Vidyabai versus Padmalata, comma, that the primal duty of the court is to decide whether the amendment is necessary to decide the real dispute between the parties. Full stop. Only if such a condition is fulfilled, comma, the Supreme Court held that the amendment is to be allowed. Full stop. Next para, such condition is fulfilled in the present case. Full stop. Next para, the Supreme Court went on to observe that in view of the proviso appended to Order 6 Rule 17, comma, the power of the court is restricted and puts an embargo on exercise of its jurisdiction. Full stop. Next para, unless the jurisdictional fact is found to be existing, comma, the court will have no jurisdiction at all to allow the amendment of the plaint. Full stop. Next para. A composite reading of Order 6 Rule 17 of the Code of Civil Procedure along with the proviso clearly indicates that in the court may at any stage of the proceedings allow either party to alter or amend pleadings. Full stop. Next para. It is also settled by the consistent view of the Supreme Court that in case of amendments of written statements, comma, the court is more liberal than that of plaint. Full stop. Next para. The said proposition has not been deviated from in the judgments cited by the petitioner as well. Full stop. Next para. In the present case, comma, paragraph 12 clearly indicates that the defendants inherited the property of one Bhagavat Singh, including the entire scheduled property. Full stop. In the amended para 12 small a bracket, comma, the defendants only seek to bring on record the chain of transactions which conferred title upon the defendant through Bhagavat Singh. Full stop. Next para. Although evidence is not required to be pleaded, comma, the surrounding facts leading to the issues involved in the suit are definitely required to be pleaded for a complete adjudication of the suit. Full stop. Hence, comma, in the present case, comma, the court being of the opinion that it was necessary for the complete adjudication of the suit to allow the amendment, comma, the said exercise cannot be faulted here. Full stop. Next para. In any event, comma, the litigant being a layman, comma, cannot be saddled with the liability of negligence for not having brought the facts on record previously. Full stop. In such perspective, comma, taking a lenient view of the amendment sought by the petitioner, particularly sought by the opposite party, particularly since it aids in the complete adjudication of the controversy between the parties, comma, there is no scope or requirement of interfering with the impugned order. Full stop. Accordingly, CO 1180 of 2023 is dismissed without any orders to cost. Should I give a direction for this suit to be decided early?
Yes.
However, comma, it is expected that the learned civil judge, junior division, 4th court at Howrah, shall decide the suit between the parties bearing title suit number 43 of 2016, comma, as expeditiously as possible, comma, preferably within 6 months from the date of communication of this order to the trial court.
Not only one thing, Lord, your Lordship has also made provision, Lord, for me to recall my evidence if required.
I've not made provision, but in any event under law, you have that provision if need be. Unless required, Mr. Kormakar, why delay your own suit? Although you are in possession.
Cost remains, Lord.
আচ্ছা আরেকটা লাইন অ্যাড করে দাও it may be it is required to be observed here that since the defendant stroke opposite party occasioned a huge delay in taking out the amendment application comma thereby putting the plaintiff stroke petitioner to much inconvenience comma the costs imposed by the trial court is modified from rupees 700 to rupees 7,000, which shall be paid by the opposite party to the petitioner within a fortnight from date. First up, যেখানে CO number dismissing বলেছি, dismiss এর বদলে disposed of in the light of the above observation. CO number such and such is disposed of in the light of the above. Thank you.
I'm deeply obliged.
Item number 7.
Yes. Saldar, yes.
That's the matter, submersible pump applied, and now my learned friend
Inspection has been held, Ms. Bas.
today in the morning, they have served a copy.
What do you say in the report?
There is some objection, they have stated. Reporter দাও just হাতে লেখা, টাইপ করে দেয়নি।
Hello, inspection was,
He has refused to allow. This person has refused to allow. There is an objector.
I'll not go through the report, my lord.
Please use the microphone. Yes.
My lord, 6% was present, first page, my lord.
Yes.
6% was present, my lord. Behal Ali Molla, Ali Ahmed, Sahib Ali Molla, Mafiuddin, Hayat Ali Molla. They were present, my lord. But a Hayat Ali Molla, his plot is before petitioner's plot. And my lord, statement of Hayat Ali, I will not allow to pass any line that is LT or HT line over my land with such and such plot number. And others, my lord, they have given objection but refused to put their signature. So my lord, petitioner also submitted a statement of petitioner also submitted that Behal Ali Molla also submitted that though there will no problem if connection is given, but he agreed to submit a alternative way leave, but till date that has not done, and until and unless the owner of the plot is allowed us to erect line or erect pole or layout the
Hayat Ali
line.
gave a written objection. This Hayat Ali
In spot, my lord, at the time of inspection, in spot, all of them were present along with the petitioner.
If there are so many objections, Mr. Haldat, I'll relegate you to the district magistrate. Go there.
Or the objector name be impleted here, I will serve copy, let it be disposed of.
That will prolong the process only, because if they take up specific objection, it is going over their land. Ultimately, you have to go under the work of license rules. So that I want to cut that short. Yes. Learned counsel for the petitioner submits that the petitioner sought a new electricity connection for operating his submersible pump. For sub next para, a report is filed by the WBSCDCL through counsel, which indicates that at the time of inspection, several persons of the locality objected to the connection being given to the petitioner.
Also the plot owners, nearby plot owners.
Yes. Given objection to the connection of the petitioners being given to the petitioners, full stop. The premise of such objection was primarily that they are the adjacent plot owners. Full stop next para. Since disputes of such nature are required to be adjudicated under the relevant rules by the concerned district magistrate of the locality, it would only be appropriate if the matter is referred to the said authority. Full stop accordingly, WPA 14068 of 2023 is disposed of by granting liberty to the petitioner to approach the concerned district magistrate having territorial jurisdiction in the area to obtain necessary orders from the magistrate and resolution of the dispute between the petitioner and the objectors in that regard. First up, next para, a copy of the report be kept on record. First up, another copy of the same has been handed over to the learned advocate for the petitioner
I have handed over, my lord.
during the course of the day.
I have handed over, my lord.
I've recorded that.
Please, my
Full stop. Next para, as such, comma, it would not be inappropriate for the petitioner to indicate to the district magistrate as to who are the specific objectors. Full stop. Next para, upon such approach being made, comma, the district magistrate shall decide the issues in accordance with law and resolve the matter, comma, preferably within 8 weeks from the date of such approach being made by the petitioner. No address to cause.
Hello, this WBSCTCL may be called at the time of hearing by the.
Yes, in accordance with law means all.
And no affidavit has filed, my lord.
They have not alleged anything else.
দিয়েছি।
No.
Item number 8, my lord, this is item number 8, my lord, I am for the petitioner, my lord.
Right.
Here the submersible pump applied for twice.
But I beg to be excused on the last occasion, it's like I could not appear.
Yes.
And when my junior also, my lord, failed to, my lord.
You have to prepare your junior, Mr. Nayak. Put him in the panel also. He is consistently available when the matter is called on. He is otherwise diligent.
I will try, my lord.
Put him in the panel also so that he can deal with these small matters. All of them are competent. Yes, Mr. Nayak.
My lord, here he made application for, my lord, new connection on 20th of March. Now, my lord, on the very next day, inspection was, my lord, held in his presence. And a detailed inspection report was prepared, where, my lord, he has put his signature also. It is shown, my lord, 8 number of poles would be required, which, my lord, cost very much, and which is beyond the, my lord, this scope of, my lord, this technical feasibility, which is, my lord, allowed by the company. Normally, in a case of, my lord, this horsepower connection, per horsepower 40,000 is the, my lord, amount to be spent by the board. Here 8, he needs, my lord, 5 horsepower. So
8 poles are required.
8 required, and my lord, his requirement is 5 horsepower. 2 lakhs involvement, where if had it been, my lord, covered within that, board would have spent it of his own. But since it is going much beyond, it is beyond the, my lord, permissible limit as per the WBC's regulation. So it has been communicated to my learned friend.
He has to pay 2 lakhs, about 2 lakhs.
Not 2 lakhs, more than 2 lakhs. Because 2 lakhs, board would have done this, but it is going much beyond that. Therefore, it is technically, it is not feasible. That has been communicated to the petitioner. Petitioner, neither it has admitted nor
Mr.
has
Halder, isn't it your liability because you have distribution rights in the area?
And we have also communicated it.
Isn't it your liability to create the infrastructure?
No, that is, my lord, day to day is being improved. Certainly it will be done, but not within the time span of 30 days as he is asking for. Within the area, it has to be, my lord, developed. And it has been communicated.
In that area, he is the only one who will be catered by those 8.
Particularly in this line.
For giving it to him, it has...
Only, yes. There is no such connection to be given.
Then you have to pay, Mr. Halder.
So, my lord, we have communicated to him. His father has received it also.
What do you say?
My lord,
he has not challenged
we
it.
have applied this earlier 2013. They have not said. Now they are coming into 2022.
Certain record we don't have any. We have no record.
Then let it be not today. I'll take instruction on this point.
No, I'll decide the matter. If you pay, you will get the connection. The petitioner submits that the petitioner seeks to operate a submersible pump and applied for electricity connection for such purpose. Full stop. Next para, learned counsel for the WBACTCL, on instruction, submits that about 8 electricity poles are required to be installed to give connection to the petitioner solely. Full stop. Next para, hence, huge expenses are necessary. Full stop. It is further submitted that the WBACTCL could have undertaken the project at its own cost if the total expenditure was below rupees 2 lakh. Full stop. However, since the costs estimated by the WBACTCL much exceed the said amount, it is not possible for the WBSETCL to bear the amount. Full stop. Next para. Although under normal circumstances, comma, it is the distribution licensee which has exclusive distribution rights over a particular area to ensure that all nooks and corners of the area are connected with electricity, comma, the said concept is a bit idealistic, comma, keeping in view the ground realities in India, full stop. As such, comma, unless the petitioner bears the costs for giving such connection, comma, the WBSEDCL cannot be compelled to give such connection to the petitioner. Full stop. Accordingly, WPA 14492 of 2023 is disposed of by granting liberty to the petitioner to pay the costs as estimated by the WBSEDCL, comma, which estimate shall be raised and communicated to the petitioner by the WBSEDCL within a fortnight from date, comma, upon which the WBSEDCL shall give the electricity connection to the petitioner at the earliest, comma, positively within 4 weeks from the compliance of such formalities. No orders to cause urgency. You will give, within a fortnight, you will raise the bill and estimate, give it to him as cheap as possible for you. And if you can pay, then
And upon payment,
after payment within 4 weeks, they'll give connection. Grateful. Thank you.
Item number 9.
9.
And I'm appearing for the respondent authorities, my lord.
My lord, I am led by Mr. Kollol Basu. My
Yes,
lord,
he argued yesterday on the last.
my lord, I am paying for short passover. My
No,
lord.
no passover. Top matters, no passover.
And on the previous occasion, my lord, Mr. Chaudhary, while making his
Yes,
submissions, had
Mr.
indicated that
Mr. Basu has indicated that he would not appear. He is probably not coming for that reason.
I wouldn't know. I wouldn't.
He said that he
No,
would.
no, no, he will appear. He will appear, my lord. That he is on his legs.
An adjournment is sought by the petitioner. Let the matter stand adjourned till tomorrow, as a last chance to the petitioner. But
There's certain emails that are there. I'll place it tomorrow when Mr.
tomorrow when I
Basu is
take up
present.
comprehensively.
Yes, ma'am.
Last
My
chance to
lord,
the
my lord, it
petitioner.
is on 8 September.
Tomorrow. Next.
Tomorrow, my lord, tomorrow. My lord, can it be on 8?
Tomorrow, if you don't come, I'll dismiss for default then. Yes.
Item number 10.
Yes.
In my lord, I beg to appear for the petitioners. My lord, it is a leave matter granted by your lordship on yesterday, my lord. I have already served, but my lord, the affidavit I could not prepare, my lord. I shall undertake to file it in course of today, my lord.
What is the matter?
My lord, matter is, my
Have
lord,
you been able to serve the respondents?
my lord, I have served upon the state respondent.
State is the main party. You are for the state.
No, my lord, the
State advocate Banerjee.
HDB Financial Services.
HD, yes, they have been served, my lord, through hand, my lord.
What is the matter about?
My lord, 13(4) notice has been issued. Section 14 order has been, my lord, already.
What is the
taken.
scope of interference?
My lord, I have already approached the tribunal, but a tribunal is not functioning at the present, my lord. I'm just praying for, I have already approached, my lord. I have filed, my lord. I have already obtained the diary number, but they are not issuing, my lord, the final number and not giving us the date, my lord. I'm just praying for an interim protection so that, my lord, I can take steps.
Tribunal was functioning till a few days back.
Yes, my lord. Now presently they are not functioning, my
Where
lord.
have you stated that?
My lord, kindly. Kindly grants me some moment, my lord.
Yes. Paragraph 12, probably.
My paragraph 12, my lord. Yes, my lord. I'm grateful. My lord.
Service has not been affected yet. You are appearing?
Yes, my lord. Yes.
Very good. Yes.
Lord, service has been affected on the state.
No, state is not the.
Yes,
the
my lord. Service has
HDB
also been affected with the bank. My lord. My client is on the way, my lord. He has personally served. So, your lord,
My lord, State Advocate Indu Mouli Banerjee.
Your Lordship, I am appearing for the state, Your Lordship.
Yes.
Bank. Oh, my lord, bank has also been served. The affidavit of service is not ready because.
File it during the course of the delivery.
Yes, ma'am.
If the tribunal is not functioning,
Not functioning, my lord. The
regularly.
worst predicament is, my lord. Kindly see, my lord, page 120. My lord, the last page where, my lord, I have been given the diary number.
My lord, my IA is ready, everything is ready. Till today, my lord, they have failed to give me an SA number. Absolutely remediless.
The on the prayer of learned counsel for the petitioner, the petitioner is directed to file the affidavit of service during the course of the day. Full stop. It is submitted that due service has been effected. Full stop. In fact, the state is represented through counsel, although none appears for the other respondents. Full stop. Next para. The petitioners submit that the concerned debts recovery tribunal, where the petitioners have already applied under the due provisions of the SARFAESI Act 2002, is not functioning regularly, the petitioners will be rendered remediless. First up, in the circumstances of the present case, an order has been passed under section 14 of the SARFAESI Act 2002. First up, the petitioners have preferred a challenge before the tribunal, but has not yet obtained any number, although the diary number is disclosed by the petitioner. Full stop. Next para. In such circumstances, the petitioners seek to invoke the principle of ubi jus id remedium. Full stop. Next para. Since the petitioners have pleaded that they have already approached the tribunal concerned, for the ends of justice, the petitioners ought to be given a limited window for moving their application before the concerned debts recovery tribunal. So accordingly, WPA 21634 of 2023 is disposed of by granting the petitioners permission to move the application under section 17 of the SARFAESI Act 2002 before the concerned debts recovery tribunal. First up, the debts recovery tribunal shall allot a proper number to the petitioners on the basis of the applications filed by the petitioners within 48 hours from the date of communication of this order to the tribunal by acting on a server copy of the order without insisting upon prior production of a certified copy. Full stop. The tribunal shall also take up for hearing the interim prayer of the petitioners on the basis of the application filed by the petitioners before the tribunal, within a week from the date of communication to the tribunal. Full stop. Next para.
May I only intervene once because
yes,
official news I cannot say, but the unofficial news till the puja vacation, the tribunal is not going to sit. So even if your lordship passes such direction, perhaps no fruitful objective will be served. Because I have to take out my application, put up application, then if the bench is not functioning, the PO bench is not functioning at all.
No, some bench must be functioning. Till last week it was functioning.
No, till 31st, it was functioning. That is the last day, he sat here. After that, he has now moved to Shiliguri. So, it will be really difficult. And since, section 14, police has already come to my house, it will be difficult,
No, then you have to go to Shiliguri. What can be done? Go there, roam around, move your matter, come back. No, I cannot give you more than 2 weeks.
The lordship will put it in such a way that if the tribunal takes, in that way, if there is lacuna on my part, then I should suffer.
No, not that.
If the tribunal does
next
this,
para. Hence, even hence CO number to WPA dispose of policy. Without going into the merits of the case of the respective parties, there shall be stay of section 14 order has been passed.
Yes, it's annexed.
There shall be stay of operation of the order passed by the district magistrate.
But this is the chief judicial magistrate.
By the chief judicial magistrate Barashat under section 14 of the SARFAESI Act 2002 till September 22, 2023 or until further order, whichever is or until further order, as and when passed by the concerned tribunal, whichever is earlier. Push up. It is made clear that this court has not even appreciated prima facie the contentions of the parties, and it will be open to the tribunal to pass orders independently and without being prejudiced by the observations made herein. First up, the tribunal shall also be at liberty to vary, modify, extend, and or vacate the order passed herein. First up, next para, liberty is given to the petitioners to mention the matter before this court in the event the tribunal does not sit even for once during the till September 15, 2023. Till 22nd September, there will be this order subject to variation by the tribunal. The tribunal, if the tribunal does not sit even once by 15th,
I shall mention the matter, Your Lordship.
Grateful, my lord.
Thank you. Thank you. Next.
Item number 11.
11, yes.
My lord, I have got the petition.
Yes, Mr. Chatterjee, what is the matter?
Your lordship,
So
I'm the-
three brothers, two brothers are before your lordship. And respondent number 7 is the another brother. Now, what has happened, lordship, respondent number 7 has availed a loan by mortgaging his own land, which is adjacent to the land situated adjacent to the property, that is the joint property, belongs to petitioners, both the petitioners as well as respondent number 7. There is a building on that. Lordship,
You two have purchased a separate plot.
Lordship, respondent number 7 has purchased a separate plot. It's a different plot. He has taken a loan, and Lordship, it's a vacant land. For that, that has been
It is adjacent to your common property.
yes. Now, Lordship, the bank, while we got the DM order, DM order shows, Lordship, kindly come to page number 63, that all that, the schedule of the property, all that part of the parcel of Bastu land admeasuring.
You are for the finance.
Your lordship, for the bank, I'm paying for Passover. My senior is engaged in courtroom number 652.
You are there. You are sufficient. Yes.
Admeasuring 91 shatok, 91 decimal together with all building existing or to be constructed therein in future in Mouja, Gajipur,
yes,
such and such. Now, Lordship, these 91 decimal has included the joint property also, because that can be apparent from the deed which I have given. This is a joint property deed which is in page number 25.
What were you doing when the order was passed by the tribunal?
Lordship, we did not know, because it might have.
So your remedy lies before the tribunal. You cannot come.
Because
To
we
this
are
court.
not the, we have not availed the loan.
You have not?
Respondent, the petitioners.
Any
here,
person aggrieved can
they
come.
are not.
No, no. The schedule was there from the inception. Your brother must have been knowing. There is no strained relationship with your brother. You are just set up by your brother to stall the proceeding.
Lordship, it's a joint property, the residential property. But the property which has been mortgaged
This
is
point could only be taken by you before the tribunal, the district recovery tribunal.
Lordship, another thing is that there is a discrepancy between two documents. One is our document.
Reach court cannot go into this. There is a specific forum for that. Go there.
Lordship, kindly, I have made one representation also.
Representation won't do. You have to file a proper application under section 17.
To the superintendent of police, I made a representation.
He won't be able to help you. He
No,
won't be able to.
That I don't know.
No, Mr. Chatterjee, go to the tribunal.
Lordship, kindly give me liberty.
The petitioners submit that the petitioners jointly own a property along with respondent number 7. Full-stop. Respondent number 7 purchased a different property adjacent to the said joint property and had taken a loan therefore. Full-stop. However, subsequently the petitioners came to know that in the garb of executing the dues of the bank for unpaid loan by the respondent number 7, the bank is trying to take possession of the entire property, including the joint property of the petitioners as well. Full stop. An order under section 14 of the SABYASACHI Act 2002 has also been filed to that effect. Full stop. Next para. Upon hearing learned counsel for the parties, it transpires that the remedy of the petitioners lies before the concerned debts recovery tribunal, since section 17 of the SABYASACHI Act 2002 is wide enough to accommodate any person aggrieved by any steps taken under the SABYASACHI Act. Full stop. Since no strained relationship between the petitioners and the private respondent has been pleaded, nothing prevented the petitioners from approaching the tribunal with the disputes as raised now. Full stop. Hence, there is no scope of entertaining the present writ petition. Full stop. Moreover, a factual inquiry is required to be undertaken for ascertaining whether the petitioners are justified in arguing that their property has also been roped into the secured assets of the respondent of the bank. First up, next para. In such view of the matter, WPA 21693 of 2023 is disposed of by granting liberty to the petitioners to approach the concerned debts recovery tribunal with the reliefs as sought herein. Full stop. If so approached, comma, the tribunal shall decide the same independently and in accordance with law without being influenced in any manner by any of the observations made herein. No rest to cause.
Much obliged.
Grateful, my lord.
2 p.m.
Affidavit of service be kept with it.
After like. Thanks.
Item number 12.
Yes.
My lord, I am appearing for the licensing.
Right. Yes, Mr. Haldar.
This is also
Submersible.
submersible form.
Why not given?
applied for-
My lord, in this matter, techno-economical feasibility, my lord.
What they are using, my lord, kindly page 10, annexure P2, middle portion, techno-economical not.
Yes. That is the regulation, Mr. Haldar.
Yes,
Challenge
my
the
lord.
regulation before some appropriate forum. Not possible to give relief, sorry. Learned counsel for the petitioner argues that the petitioner seeks to operate a submersible pump and requires electricity connection, comma, for which an application was made. Push up.
Let it be GRO.
GRO cannot.
GRO.
GRO can decide this is very well. Learned counsel for the WBACDCL, however, places reliance on annexure P2 at page 10 of the writ petition, which is a communication made by the WBACDCL to the petitioner, pleading that techno-economically, comma, the connection sought by the petitioner is not feasible, comma, for which the connection could not be given to the petitioner. First up, next para. Since the dispute herein pertains to the question as to whether it would actually be possible to give connection to the petitioner, comma, taking into contemplation the techno-economic aspect of the matter and whether a new substation is required to be installed, comma, the petitioner's appropriate remedy lies before the concerned grievance redressal officer. First up, accordingly, WPA 15996 of 2023 is disposed of by granting liberty to the petitioner to approach the concerned grievance redressal officer for the reliefs as sought herein. First up, if so approached, comma, the GRO shall decide all issues in accordance with law as expeditiously as possible, comma, positively within 10 weeks from the date of communication of this order to the GRO. This will require 10 weeks.
Yes, ma'am.
First up, no rest to cause.
I'm grateful, my lord.
Item number 13.
13, yes.
Lordship, I am for a petitioner.
My lord, I am for the postal department. My lord, before initiation of the matter, my lord, the petitioner filed another writ petition alleging the same allegation and suppressing this petition. My lord, I have got the status, my lord. My lord, kindly let the matter be WPA 3620/2020.
Where is it? Is it appearing in some list?
No, my lord. My lord,
Yes, what do you say regarding this?
Lordship, I am not aware of.
Yes, my lord,
Your lordship,
let the
break
matter
for
be.
what today?
Who are you?
I'm defendant number 3, led by Mr. Shruti Palchowdhury.
Take instruction, come back tomorrow.
Lordship.
Learned counsel for the postal department, comma, at the outset, comma, submits that another writ petition on the self-same cause of action bearing WPA number 9226 of
No, my lord, 3620. 3620/2020.
bearing WPA number 3620 of 2020 is pending before this court. First up, next para, learned counsel for the petitioner does not have any instruction on such score. First up, to enable the petitioner to come prepared and address the court on such issue as well, comma, the matter is adjourned till tomorrow when it will be listed under the same heading. First up, an information slip in support of the contention of the postal department filed today by learned counsel for the said authority, comma, be kept on record. Come back tomorrow for that, and if you have instruction that is also on a self-same cause of action, then I'll direct both to appear together and take up the matters.
First is the filing number, second is the WPA number.
Yes, I made a mistake. Thank you.
No,
Please give your names, all of you. Ma'am, please give your name also. Yes.
Item number 14.
14,
Not I wish to appear on behalf of the
Right.
petitioner, my lord.
yes.
Lord, pursuant to your lordship direction, my lord, I have again, my lord, served the, my lord, state.
State chooses not to appear, move your word.
Lord, this is my.
Good service, you have checked up.
Yes.
File the receipt. Thank you. Yes,
Lord, this is my second round of writ application,
yes.
paying for a direction upon the registering authority to hand over the registered deed, which is lying with the registering authority post registration. I have been given the IGR receipt on the virtue.
What is their ground disclosed by them?
Yes, my lord. And kindly, my lord, come to page 64. That is the order of this honorable court. When it
Yes,
was disposed of last month.
yes.
Page 64. my lord. The respondent number 5 in his affidavit in opposition to the petition has disclosed that those deeds are involved in the pending Ashoknagar PS case number 184 dated 7 June 2007 under section so and so, and a vital piece of evidence in the said criminal case.
Have you taken instruction regarding the, I've seen the order.
Yes, my lord. I have, my lord. Then, my lord, I have.
Are you a party there?
No, I am, my lord, not party there.
What's the
my lord,
matter
but
about-
I have, my lord, got the certified copy of the order which has disposed the case as on 3rd of October 2013. My lord, that is at.
Can you
page-
take information regarding what happened to the deeds? Because you have to approach that court and take it.
My lord, deeds are lying with them. My lord, kindly.
Lying with that court.
No. Deeds are lying with the registering authority itself.
Those were never produced as evidence there.
No, my lord, no.
The case was
My lord,
dropped.
I will show it from the one lord order. There is.
So imagine the case was dropped.
Yes, my lord, case was.
You check up from the order,
Yes, my lord. This, my lord, might.
read the ordering portion and then hand up.
Yes,
Read it and hand up.
my lord. The proceeding against accused person number so and so, Ashoknagar PS case number under so and so, registered as a special case number is hereby dropped.
Pitamurti. Which authority should be directed?
My lord, my lord, kindly comes to page 67.
District register or additional district sub
My
register?
lord, it is now, right now, it is lying with the DIGR range 2 district register.
District
is-
register.
Because, my lord, in page 67, when the state appeared on the last time, they have stated that it is lying under sealed cover.
Acha, act order. Despite repeated service, none appears for the respondents. As such, the matter is taken up for hearing ex parte. Affidavit of service filed today in court be kept on record. First up, the petitioner presented a deed for registration and, even after the registration was complete and IGR number was allotted, the deed was never handed back to the petitioners. First up, next para, accordingly, the petitioners were constrained to approach the registering authorities. First up, however, since no response was received from the said authorities, a writ petition was filed by the petitioners. First up, in an order dated June 20, 2019, the writ petition bearing WP 17814 within bracket W of 2010 was disposed of by a coordinate bench. First up, it was observed that the respondent number 5, that is the registering authorities, in its affidavit in opposition had disclosed that the deeds were involved in a pending Ashoknagar PS case number 184 dated June 7, 2007 under certain sections of the Indian Penal Code and section 81 of the Registration Act 1908 and a vital piece of evidence in the said criminal case. Have you tallied yourself the number of this?
Yes, my lord. Yes.
Next para. Learned counsel for the petitioner hands over us and files a supplemented affidavit with leave of court, where a certified copy of the said criminal case has been annexed. First up, it is clearly seen from the order passed therein on October 3, 2013, that the said criminal case was dropped as on that date. First up, next para, the ordering portion of the said Criminal Court's verdict says that the proceeding against the accused persons as named therein were being dropped. Full stop, next para. Upon the said criminal case itself having been dropped, comma, there is no further occasion for the plea of the registering authority to withhold the document from the petitioners any further. Full stop. Accordingly, WPA 3999 of 2022 is allowed, comma, thereby directing the respondent number 4, that is the district registrar, comma, Barasat, comma, North 24 Parganas, to hand over the registered deeds of the petitioner as mentioned in the present writ petition to the petitioners at the earliest, comma, positively within a week from the date of communication of this order to the said respondent. Full stop. The respondent number 4, comma, for the purpose of compliance, comma, shall act on a server copy of this order coupled with the written communication of the learned advocate for the petitioner, comma, without insisting upon prior production of a certified copy. No address to cost charges.
I am to
Thank you.
Item number 15, my lord. And I'm appearing for.
My lord, the grievance has been settled. My lord, kindly dispose it of by recording that submission.
Can you please take the microphone, Ms. Korghosh? Yes.
Lordship will kindly pardon me from the embarrassment. Perhaps your lordship may not be inclined to take up this matter.
I appeared. Father appeared.
For the
Anyone of my forefathers appeared?
The matter will be
just
No, did I appear for one of the parties?
for the petitioner.
Do you agree that it has been
It's a civil
My lord-
petition matter, my lord.
no, settled out of court?
yes. The
My lord, I am a respondent number 1, 2, 3.
has
my
come
lord,
up at
and
his
the-
instance.
Settled.
My lord.
Acha. Learned counsel for the respondent number 4, comma, in her usual fairness, comma, points out that I had appeared for one of the parties prior to elevation, comma, in CO number 1491 of 2014. Full stop, next para. However, comma, in view of the submission of both the contesting parties, that is the petitioner and the respondent numbers 1 to 3,
My lord.
1 to 3, that the matter has been settled out of court.
My lord. It's
Sir,
net
settled
settled
to the
matter.
extent of, my lord, the bank account has been directed to be operative.
My lord, the
Defreeze, my lord, on
Defreezed.
21st of May, 2023. But only thing, may I just intervene, my lord? There is an amount of rupees 5,000, my lord, which belongs to the respondent number 4 wife, my lord. So that may be released, my lord, from the bank.
No, that will be an adjudication.
my lord, may I indicate one thing, my lord? My lord, the read petition was a grievances against respondent number 1 to 3 to unfreeze the account, my lord. And the petitioner have obtained the order from the lower court, my lord, to unfreeze the account, madam. Pursuant to that order, we have unfreezed the account, my lord. So there is no,
Lordship, it is a joint account, my lord, which was opened by the respondent number 4 and the petitioner, my lord, just after their marriage, my lord. Thereafter, my lord, the respondent number 4 was not in a position to operate. Till date, my lord, she is living separately for the last 20 years.
And that is a dispute which is going on separately. But it cannot be the subject matter here.
5,000, my lord, which belongs to the respondent number 4, which is lying in that account, my lord.
Let me see the relief shot here. That will. Mr. Bhattacharya, respondent number 4 is a wife.
It's a wife.
She has a claim to your this thing. I mean, even recording this might be to the, I mean, contrary to her interest. And I appeared for you, your client. So I better not. Order to keep them. Learned counsel for the respondent of 4, comma, in her usual fairness, comma, points out that I had appeared for one of the parties prior to my appointment as a judge in CO number 1491 of 2014. Full stop. Although learned counsel for the petitioner and the respondent numbers 1 to 3 bank submit that the dispute between the said parties has been resolved to the extent that the account of the petitioner has been defrozen by the respondent number 1 to 3 in the meantime, comma, since the respondent number 4 has apparently has a claim to the said amount, comma, it would not be prudent for this court to take up the matter, even for recording that the matter has been rendered infructuous by way of settlement out of court. Full stop. Hence, comma, for the sake of propriety, the writ petition is released from my list with liberty to the parties to pray for assignment before an appropriate bench, before an appropriate bench.
It
Full
will
stop.
go down to the honorable chief, usual process.
Yes. Please take this back. Your submission is sufficient. You need not hand over documents for that. Yes. Need not. The CO number I have recorded. You are saying I appeared for the parties, that is sufficient. Yes. Next.
Item number 16.
I am appealing for the petition.
Petition.
My lord, I'm being led by Miss Monica Roy, the learned counsel of the Food Safety and Standard Authority of India.
Very.
Lord, in
My
this
lord,
application.
My lord, as per the earlier direction of the Honorable Court, it was directed upon the learned counsel of the FSSI to submit the short note indicating all the provisions relevant to this instant writ
It
petition.
was heard substantially then.
No, my lord.
Should it go before the other bench? Would it be proper for me to take up? Short
Yes,
notes are being filed.
Yes, my lord. My lord, it was, my lord, on that day, my lord, they could not submit something on the queries of the court.
Acha, very.
That's why
This short note.
only, my lord, this short point involved in this case is that whether FSI authority, without any testing, only on the basis of visual inspection, can reject the clearance of the goods where the permission of the FSI authority is required.
What is the concerned law?
Concerned law is that they
Show
will
me that.
test the thing, and for the testing purpose, they have made me to deposit the testing fees.
No, what is the governing law or provisions of law? Is there any provision? This is under which act?
Food Safety and
Standards Act 2006.
Yes.
What is the provision? They say that on visual inspection they have what? They have withheld the samples.
Yes. And rejected clearance. But this,
Acha.
shortly, the facts of the case is
Yes.
that, my lord, I have exported some tea, some quantity of tea,
Right.
to Paris, and out of that some quantity, the foreign buyer found some quantity is not according to their goods as ordered. No, some quantity they have returned, and those quantities I have requested for the customs authorities for clearance, and for the sake of such clearance, FSI authorities, no objection is required. Now, FSI authority, I have submitted the no objection, the declaration for no objection, and as per requirement, I have also submitted that for what purpose I am getting it cleared for this. I have stated in my application that it in my letter that it is being cleared for making further preparations and for sale in the domestic market. After even taking the approval, without taking the approval of FSI authority, my lord, it cannot be sold. Therefore, after making proper processing, it will be cleared again after taking approval of the authority. My lord, thereafter, my lord, the FSI authority directed me to deposit the testing cost. I have deposited 58,000 as the testing cost. Thereafter, on the visual inspection, they found that it is some best before date has been used on the packet, which has been suppressing one date below that, and therefore it is misbranded. Therefore, there is only visual inspection. No testing has been done, and nothing has been found that it is not cannot be used.
No, if it is seen that there is some manipulation regarding the dates, is any further sampling necessary?
No, it is not a case of manipulation. My lord, what is the case? Case is that, my lord, I am purchasing the packets from the markets.
Right.
In the markets, big packets, not tea packs.
You purchase and exported.
No, tea packs. It is my tea is from me.
Your garden, your
my own product.
Is right. Yes.
Right. I am purchasing the packets. In the ready-made packets, some date is mentioned. And in case of my goods, whatever date is applicable, I have pasted that. And on that it has been exported.
Right.
And on that same condition, it has come back. But where is the question of manipulation? And on the same consignment has come back. And on this said where the June 2005 was the date mentioned, the best before date used. My lord, sees the order.
Yes. Let us see that.
Well, kindly see, kindly come to page. For a glance, my lord, kindly see page.
60,
Page, page 18, my lord.
18. That's
Yes.
Yes.
This is the bill of, this is the shipping bill by which I exported the goods.
Right.
Now, my lord, kindly come to page 34.
44, yes.
33, sorry, 33.
33, right?
Yes. But by this letter, the authorities are, the foreign buyer is returning the goods of 48 packets of 927 kgs, big returning. Now I am submitting the, kindly come to page 36. 36, I submitted the bill of entry for clearance of that goods.
Right.
Now, kindly come to page 44.
Yes.
No objection certificate, for no objection certificate application I have also made before the authority.
Right.
Now kindly come to page 48.
This no objection certificate is to be made before the FSSI.
Yes.
Very well.
Seeking there no objection, I have to make it.
Right.
Yes. Now come to page 48.
48.
48, my lord. Here no objection certificate here I have submitted, and they have directed me to pay 58,550. In the middle column, my lord, I paid just after first paragraph, second row, my lord. 5805.
I'm sorry, page 48.
48. Second row, last column, 58,050 I have to deposit.
Oh, yes. Sorry. Got it.
So, and kindly come to then page 50.
But what about this application rejected, the following ones?
Application rejected, my lord.
Remarks.
Here, different packets were there.
Achha, you are only on this 58050, this packet.
Yes.
So I'll come to page?
Count to 50.
50, yes.
Yes. I have been granted a receipt for testing the report for deposition of 58050 for testing purpose.
Yes, you paid that amount.
Yes.
Right.
That given that amount. Now, my lord, I have given a declaration for, I am required to give a declaration for end use of the re-imported good, page 51. After para 4, my lord, being re-imported for
local market sale.
For further process and use in the local market.
Yes.
It was originally exported. That's all. So my object was I have indicated.
Right.
Now I will kindly come to page 52. What is the order?
Yes.
This office is not in a position, my lord. It is the office FSI order.
FSI office, right.
This office is not in a position to issue no objection of the products mentioned above. As a result of the inspection, always analysis shows that the samples do not conform to the specifications under FSI Act 2016 and rules regulations made thereunder. This is for your information necessary action. The returned goods of tea was scrutinized, and but only on the basis of visual inspection, it has been, they have arrived at the conclusion that it is not fit for clear.
Visual inspection, they say shelf life is not sufficient and all these things.
All the things.
So you say they had to also sample.
Yes, they should take sample, and if it is found that it is not grant.
Very good.
Well, this is the order they have passed. Now, by this order, they have also said, my lord, this portion is very important.
So yes, please.
The remark portion, the returned goods of tea was scrutinized, and at the time of visual inspection, it was found that the balanced shelf life of the item is not sufficient. That is neither 60% of the shelf life for 3 months before expiry, thereby violating Rule 5 and 6 of the Food and Safety Standard Rules and Regulations. 17. The date of manufacture is found to be May 2001. At best, before 12 months is printed on all bags of the item. Further, white stickers were pasted on all bags to best before use June 2025 to match the original. This is entirely misleading and entirely incorrect. Lord, I have already submitted, my lord. I have purchased the bags from the market.
So you had no custody of those goods after exporting them. So you could not be liable for this misbranding.
Misbrand. I have no scope. I have no scope
And if
for,
it was done, it should have been some other authority or
Yes.
some other entity. Because at the time of export, that was scrutinized, must have been.
yes, that this was scrutinized and this was exported.
This is on the second part, and the first part, violating regulation 5(6), that you said there had to be a sampling.
Yes. Yes, my lord, then my lord, I filed a review application. In the review application, my lord, order is being passed in page 54.
Yes.
In page 54, my lord, kindly come to page paragraph 6. 6(2). The NCC was issued to the said products by the authorized officers on the ground that return codes T was scrutinized. Well, that same remark has been quoted.
Reiterated, yes.
Next 2. It is noted that for visual inspection photographs, well, again visual inspection, my lord, 12 months expiry, they are construing from the date of what was pasted in the bag earlier. And if the importer is not satisfied, again importer is not satisfied, they can again apply for review. My lord, next, my lord, next, my lord, kindly come to next order, page 63. Second review order, page 60, my lord. Page 60.
Yes.
Same order has been quoted, 6(2). Second review order, same thing has been quoted, and my lord, the no objection has been refused. As a result, my lord, my tea is lying in the custody of the customs authorities, and since then, and my lord, I am suffering demurrage every day. Demurrage charges I am being paid every day, rent charges every day, and my lord, in spite of making repeated request, even after making this repetition, they are remaining silent over this clearance of the goods. Now, my lord, I am showing some provisions of this statute where it has been mentioned in the food safety standards and import regulations.
What is the provision?
That is where I am only I am referring to 2C.
These are 2017 regulations.
Yes. My lord, it is balanced shelf life means period between date of import and best before or date of expiry as the case may be. And in my case, my lord, best before date has been mentioned. Now, my lord, kindly see the notification. Notification. Yes. Kindly see the notification.
And give copies to your learned friend also, notification.
Yes, yes.
Although these are public documents,
Yes,
but you
yes, yes.
should be aware.
Yes, yes, I'm happy. I will only show.
You have got a copy? You have got a copy?
I have a copy. Yes, give a copy.
First you get it, then I'll hear you.
Yes, I have a copy.
Please find out the copies. I'll come back in 10 minutes, Mr. Chaudhary.
Okay. Okay. HR.
Continue.
Yes, my lord. I have handed over the copy, my lord, of the gazette.
Thank you, yes.
My lord, in this, my lord, this gazette I wanted to refer because of to show the incorrectness of the order they have passed.
Right.
But before that, my lord, just I want to just place once again that order he has passed at page 52. And which has been repeated in my review applications repeatedly. This order I
Yes,
just want
yes.
to place, my lord.
Please.
My lord, the office is not in a position to issue NOC. The products mentioned above as the result of the inspection always analysis shows that the samples do not conform to the specification under FSS Act 2006 and rules and regulations remedied under. This is for your information, necessary action. Please remark. The returned goods of the tea was scrutinized, and at the time of visual inspection, it was found that the balance shelf life of the item is not sufficient. That is 60%, neither 60% or shelf life, nor 3 months before expiry. Thereby violating regulation 5(6) of the Food Safety and Standard Import Regulations 2017. The date of manufacture is found to be May 2001, and the best before 12 months is printed on all the bags on the item. Further, while white stickers are pasted on all the bags of tea or with bags more than best before date is 6 June 2005 to mark the original best before date. Thus, item misbranded. This is the reason for which they have treated that goods as misbranded, and they have refused to give me permission. My lord, the findings, whatever has been given herein, is totally incorrect and contrary to facts. My lord, firstly, the returned goods of the tea was returned goods of tea. My lord, returned goods of tea was scrutinized, and at the time visual inspection, it was found that the balanced shelf life was not sufficient. My lord, what is the balanced shelf life? Yes, my lord. Here, my lord, my balanced shelf life, I have declared it as June 2025. And the balance shelf life is much more when I have submitted the bill of export, bill of entry for the clearance in 2020 June.
No, balance shelf life has to refer to the date of manufacture.
No,
it was printed there originally from May 2021 for 12 months. That is the best before date.
Yes, but
subsequently have put in June 2025 to mask, that is their allegation, to mask the original best.
Yes.
If it is 12 months from May 2021, it expires in May 2022.
Yes, but it is not. My balance, my date is best before date is June 2025.
If that be so, then why was it printed in the bags? All the bags that it was.
Ready-made bags are available in the market for purchase.
Achha.
I have purchased the entire bags of all the bags, and my product has been filled in, and whatever best before date is applicable to my goods, I have pasted on that and exported that. That goods up after examination to exported. That goods have come back after same goods have come back, and that June date is there. And now after re-import returned goods, if you find that date is there, have I done it? It was exported as it was.
Right.
So if that is taken into
before exporting, at the time of exporting, is there any scope of FSSI looking into it?
No.
So therefore, they are looking into it for the first time. It could have been there from the beginning.
Yes.
Their contention may be theoretically correct that you might have done it at the time of export also. So you might have done this as they say manipulation. You say it's not a manipulation. I put my best before date, which is the actual best before date.
Yes.
And those are the bags are ready-made bags. And so,
yes.
So if you had any doubt, you should have sampled it.
Yes.
That is your contention.
Yes. That is my only comparison. You take the sample. If it is found to be not best before, not only thing I wanted to show, emphasize, my lord, what is my lord what is balanced shelf life? Yes. I have shown, my lord, that 2017 regulation 2C. To balance shelf life means period between the date of import and best before or date before expiry. As the case may be. My case is best before.
Yes.
Yes. Now kindly come to this gadget. In the gadget in definition 2C. 2C. Best before date. In the gadget, my lord, defined, my lord, in the definition, best before date has been defined.
This is the same regulation of 2020.
2020.
Oh no, this is a different labeling and display regulation.
It is gadget, yes. My lord, kindly see definition 2C, where best before date has been defined means the date which signifies the end of the period under the stated storage conditions during which the food product shall remain fully marketable and shall remain any specific qualities for which tacit or express claims have been made, and beyond that date the food may still be perfectly safe to consume, though its quantity may have diminished. However, the quality may have diminished. However, the product shall not sold if any stage the product becomes unsafe. So I have my contention is that in my case best before date is June 2025, and best before date it does not become unsafe for human consumption, or its quality may be diminished or something else, but it has no expiry date. Now kindly come to next page, my lord. 2U, used by or expiry, means the date which signifies the end of the estimated period under any stated storage conditions after which the product may remain safe, and food product probably will not have quality or safety attributes normally expected by consumers, and the food shall not be sold distributed for human consumption. Here,
what are the yardsticks for their giving this no objection under the act? Is there any yardstick criteria stipulated that under these conditions they'll be giving the no objection, or they'll be refusing?
They are required to give me no objection. My lord, it is statutory norms that if the no objection from this, if I not take no objection
So
from
is there any criterion in the act when they will refuse no objection or when they'll give under these circumstances? Is there anything?
Yes.
Please show me that also.
There is
Because that is the ultimate thing we have to go to.
Regulation 5. Not kindly say regulation 5.
Best before, I understand your point. Even if you say, even if it is best before, it can be used in usable condition. It should have been. So let us see the criteria under which no objection is given.
No, what I just did.
So let us come to there.
My lord, kindly come to their short note. Note they have
Yes,
given.
yes, yes, absolutely.
Given.
Page. It's not paginated.
It has not been paginated. Kindly come to. It is a boy to us.
This is
2. Page 2, page 4. Kindly come to page 4.
Yes.
Page 4, my lord. Here they are saying
in the middle.
In the middle, my lord. Kindly page 4. In the middle, my lord. 5 D. 5-6.
No. Subpara D.
Yes, 5-6.
5-6 and subpara D.
Right.
5-6 of the food safety standards regulation customs shall not clear any article of food unless it has valid shelf life of not less than 60% of 3 months or before the expiry of 3 months. But this condition is not applicable to me.
They have relied on this.
They have relied on this. So shelf life not applicable to me because my June 2025. Then my lord.
Now, why do you say this is not applicable? Oh, if June 25 is taken.
Then
yes.
Then my lord, 3 ZF I of the food safety and standards 2006 misbranded means an article of food A if it is purported or is represented to be or is being offered or promoted for sale with false, misleading or deceptive claims. Either, well, here I am. Here is the case of this, that it was 12 months. It was there. You have put it some other marks. If that is, I am saying that this is not correct. And if this is not correct, then the 3ZF is also has no manner of application. It is not a case of misbranding.
If there is a dispute, what is the forum for deciding? There may be disputes, like in this case. You say it's not deceptive. They say it is deceptive. So is there any forum?
Only thing, my lord, on the face of this, my lord, the goods I have used at the June 2025 as it is exported, it is same goods have come, and they are saying after opening that testing, they found.
So what is the question of sampling? You are relying on sampling. You are asking for sampling.
Sampling, they have stated.
What is the scope of sampling?
They have said before clearance of the goods in my writ petition, my lord. Kindly see.
Now, what is the provision where they are required to sample, take samples?
they are required to take samples. Well, it is even stated in this provision itself, in this note. In this note itself, they have stated, well, kindly come to G.
Drawing of
Drawing
sample.
of sample is subject to satisfactory compliance of necessary provisions of labeling and display, physical condition of the consignment product and satisfying the balance shelf life, failing which consignment can be rejected on visual inspection stage.
No,
I am challenging this one only. They have only visual inspection stage, they have cancelled my to issue the no objection certificate. These are as per Regulation 6861091 of the FSS Import Regulation Act. 6. Compliance with standard for packaging and labeling. The authorized officer shall reject the consignment not complying with the provisions of the labeling and packaging regulation at visual inspection, and no sample should be drawn. So they have satisfied on the visual inspection that it has been pasted on something. Therefore, if that is taken into consideration, no sampling is required. This is their case. So my case is that my case is that, my lord, respectfully submitting, my lord, it is a case where I have exported the goods stating at June.
But Mr. Chaudhary, here drawing of sample is subject to satisfactory compliance of necessary provisions of labeling and display.
Yes.
Physical condition of this consignment product and satisfying the balance shelf life.
Yes.
Now, even if they drew a sample, that would be subject to this visual inspection of labeling and display.
First, visual inspection, my lord. Visual inspection, whatever they have observed, that those observations are not on the face of it not correct. And my lord, thereafter remains only on the course remaining in the testing. But that's why I have requested for them that you test it, and if you found that it is not fit for human consumption or something else, don't allow me clearness. Only thing I wanted, my lord, that is since June 2020, my lord, if it is misbranded, I have shown it is not misbranded, because these goods were exported. These goods have only have come back, or there is no scope for my pasting or on some labeling, another pasting, putting of another pasting.
So at the time of sending, you could have done it.
I
You could have done it. I'm telling you, I'm against you now. I'm arguing for them.
Yes.
At the time of sending itself, you could have done this.
I could have done it.
So what prevents you from doing that? Because there is no FSSI at the time of export.
Because I am putting it at the time of sending, because in case of my goods, that best before date is applicable. That's why that I have put. On the date of sending, it was 12 months or what was there. But in the packets which I purchased, in all packets it is written. But big packets, my lord, will find the tea packets, and where, my lord, it is.
If FSSI could not find out, I cannot. I don't have the personal knowledge. If they could not, they're the authority of packages.
Yes, my respect to
Anyway, let us hear them, Mr. Chaudhary.
Yes.
So this is yes. Why didn't you sample if you had any doubt?
My lord, kindly see the last paragraph of the short note. If your lordship kindly sees the last paragraph, it has been stated that if your lordship allow me to read it out.
Yes, please. Yes.
Appeal to CEO, FSSI was filed by the petitioner for above consignment, on which it was decided that the said consignment may not be considered for no objection certificate on grounds observed during visual inspection as per the regulation 2 subclause 1 AB of the Food Safety and Standard Import Regulation 2000.
You are reiterating your same stand.
But kindly see, there is only one contention, that is, it has been submitted by the authority that the visual inspection done by the representative of the authorized person in order to know the physical condition of the food consignment. And herein it has pasted, it has been contended that the petitioner herein has pasted the white stickers on pre-printed packages and changed the shelf life to June 2025. And also, my lord, without providing any documentary evidence.
They were given an opportunity to provide documented evidence.
Yes, my lord.
No.
Show me the hearing given to them. Your reasoned order or any hearing given to them.
My lord, this order was passed during the second review application was filed by the petitioner.
Did they have any opportunity to hand over documents? They did not. They took out an application for review, decided and sent an email.
But at the time of visual inspection
is not dependable at all. Visual inspection was not on the sample of tea. Visual inspection was only on that label. You say the label says the that expiry date or whatever best before date is June 2025, their own pasting. Now they are entitled to paste their own best before date. There is no barred illegality in that. The distinction between that and the original printed packages which say best before 12 months. Now the competition between these two labelings, that is what prompted you to say that it was a misrepresentation. But who decides? How do you decide that is a misrepresentation? 12 months before is not the incorrect thing. Which is correct? How do you decide? There are two competing things. One is best before 12 months, which is pre-printed, and the other one is their own labels which say best before this June 2025. So in the competition, which is the actual correct date, how do you decide? The only way to decide is if you sample the teas by experts. So you'll do that. I'll direct you to do that. Before that, your visual inspection, every time, 3 times you have done it, but every time it's restricted to that labels put by them. That was sent in that conditions. The French importers did not say anything on that. They do not say that I refuse on that ground. They say it does not meet the grade and quality, their own grade and quality. That's why they return. So I'll dispose it of itself. Basically, this is much ado about nothing. You have to have it sampled through experts and give them an opportunity to produce documents. If they can produce any documents, I'll redirect you to do that only. The grievance in the present writ petition is against the refusal of the FSSAI authorities to give a no objection for the petitioners to bring back into India products manufactured by the petitioners, which were initially exported to France. Full stop. In the present case, the export, a part of the export consignment was returned by the French buyers on certain grounds that the grades and the qualities did not match their requirements. Full stop. Next. However, as per the document of such return from the end of the French importers, annexed to the writ petition, nothing is evident, nor have been relied on by the respondents themselves, to show that the French importers refused on the ground that there was any misrepresentation regarding the best before, the best before date of the products. First up, next, when the products were coming back into India, the FSSAI, purely by relying on visual inspection, came to the conclusion that there was misrepresentation stroke misbranding and that the products did not qualify for a no objection, since sufficient time was not left between the date of inspection and the best before date of the products. First up, the premise of such observation by the respondent authorities was that there were conflicting prints on the packages. First up, in the default prints on the packages, it was indicated that the products were best used within 12 months from the date of manufacture, which was in the middle of the year 2021. Full stop. On the other hand, the labels pasted by the petitioner showed that the best before date was to expire in the month of June, 2025. Full stop. If the labels of the petitioner are taken to be correct, there is much time yet left for the best before date to come. Full stop. Next. Thus, the entire premise of the consideration of the respondent authorities was a visual inspection. Full stop. However, nothing is depicted in the repeated refusals by the respondent authorities, at the first instance and thereafter on the 2 review prayers made by the petitioner, to show as to what was the reason for accepting the prior prints in the packages which indicated that 12 months was the best before period, comma, over the labels put by the petitioners stroke manufacturers themselves. Full stop. Next para. In the absence of any such depiction, comma, the petitioners argue that the respondent authorities ought to have sampled the products and satisfied themselves by appointing experts as to whether the best before dates was yet to come. Full stop. Next para. Learned counsel for the petitioners places reliance on Regulation 2 within bracket 1 within bracket small c of the Food Safety and Standards within bracket import bracket close regulations, comma 2017, which defines double inverted balance shelf life as the period between the date of import and within double inverted best before double inverted or within double inverted date of expiry, as the case may be. Full stop. Again, comma, learned counsel places reliance on Regulation 2 within bracket 1 within bracket small c of the Food Safety and Standards within bracket labeling and display bracket close regulations, comma 2020, comma, which on the other hand, comma, defines best before date double inverted মধ্যে as the date which signifies the end of the period under any stated storage conditions during which the food product shall remain fully marketable and shall retain any specific qualities for which tacit or express claims have been made, comma, and beyond that date, comma, the food may still be perfectly safe to consume, comma, though, comma, its quality may have diminished. Full stop. However, comma, the product shall not be sold if any stage the product becomes unsafe. Full stop. Next para. Learned counsel appearing for the respondent authorities places reliance on Regulation 5 within bracket 16 of the import regulations of 2017 referred to above. Full stop. It provides that the customs shall not clear any article of food unless it has a valid shelf life of not less than 60% or 3 months before expiry, comma, whichever is less, comma, at the time of import. Full stop. Learned counsel also relies on section 3 within bracket small zf bracket closed bracket small Roman I of the Food Safety and Standards Act, comma 2006, where misbranded means an article of food within bracket capital A if it is purported or is represented to be or is being, therefore Roman I bracket offered or promoted for sale with false, comma, misleading or deceptive claims, either small a upon the label of the package or small b through advertisement or small ii bracket a, sold by a name which belongs to another article of food. Full stop. Next para. Drawing of some sample, comma, it is argued, comma, is subject to satisfactory compliance of necessary provisions of labeling and display, comma, physical condition of the consignment stroke product and satisfying the balanced shelf life, comma, failing which consignment can be rejected at visual inspection stage. Full stop. Next para. Upon hearing learned counsel for the parties, comma, it transpires that the entire premise of the rejection to grant no objection was that in the perception of the respondent authorities, comma, the labels put by the petitioners themselves to the packages were false, comma, misleading and deceptive claims, comma, on which premise the respondents found that the said labels were to be ignored in preference to the prints on the packages of the products which indicated that the best before date expired 12 months after the manufacturing date, comma, which was sometime in the middle of the year 2021. Full stop, next para. However, comma, in terms of the submissions of the respondents themselves, comma, drawing of sample is subject to satisfactory compliance of necessary provisions of labeling and display, comma, physical condition of the consignment stroke product and satisfying the balanced shelf life, comma, failing which, comma, consignment can be rejected at visual inspection stage. Full stop. The construction of such sentence, comma, as finds place in the short note handed over in court today by the respondents, comma, clearly indicates that prior to visual inspection stage, comma, there has to be a drawing of sample and physical and an examination of the physical condition of the consignment stroke product for satisfaction regarding balance shelf life. Full stop, next para. In the present case, comma, there is nothing to indicate that there was ever any sampling or physical examination of the consignment or product to verify as to whether the shelf life indicated in the labels of the petitioners were correct or that which found place as printed in the packages of the product. Full stop, next para. In the absence of such examination, comma, the refusal by the respondent authorities is vitiated. Full stop, next para. Even on a consideration of regulation 2 within bracket 1 within bracket small c of the labeling and display regulations of 2020, comma, the best before date is the date which signifies the end of period under any stated storage conditions during which the food product shall remain fully marketable and shall retain any specific qualities for which tacit or express claims have been made. Full stop. Next para. To assess whether the products in question retained such specific qualities for which tacit or express claims were made by the petitioners, comma, a hearing ought to have been given to the petitioners and an opportunity to the petitioners to produce documents in that regard, comma, if the petitioners so choose, comma, coupled with a sampling of the products before observing that the pre-printed dates would override the labels of the petitioners. First up, in such view of the matter, comma, the impugned decisions annexed to the writ petition, comma, whereby the respondent authorities repeatedly refused to grant no objection to the petitioners for the purpose of importing their products, comma, is set aside. Full stop. Next para. WPA 28958 of 2022 is, comma, accordingly, comma, allowed, comma, thereby setting aside the rejection of the grant of no objection by the respondent authorities to the petitioners and directing the respondent authorities to give an opportunity to the petitioners to present their version of their case, as well as to produce documents to substantiate the tests as indicated in the observations above, as well as to conduct a physical sample examination for the purpose of ascertaining the veracity of the petitioner's contentions, comma, before coming to a finding as to whether the dates disclosed in the labels of the petitioners, that is June, 2025, is the appropriate best before date, or that printed in the packages, that is 12 months from the date of manufacturing. Full stop. Such rehearing and the entire exercise shall be concluded by the respondent authorities, comma, preferably within 1 month from the date of communication of this order to the 1 month from this date, and the outcome thereof shall be communicated by the respondent authorities to the petitioners immediately thereafter. It is made clear that the rival contentions of the parties on merits of the samples have not been gone into by this court, and it will be open to the respondents to decide the same on its own merits. Thank you. Thank you. প্রীতমের কি হলো? প্রীতমের কি? হ্যাঁ?
My lord, will be taking by item number 4.
Yes, sorry.
Item number 4, my lord.
Item number 4 টা পাস হওয়ার ছিল একটু। হ্যাঁ,
Number 4.
yes.
My lord, kindly sees the last order, my lord, I just indicated to your lordship in the morning.
ওটা হ্যাঁ।
Okay, passed by Justice Bhattacharya, my lord, indicating the court's desire to refer to the mediation, which I did not object.
এটা মিডিয়েশনে গেলে আপনার আপত্তি আছে? এটা তাহলে মিডিয়েশনে আমি পাঠিয়ে দিচ্ছি।
My lord, in mediation, we do not have perhaps any role to play. We are
You
the
are
bank. We have given loan to the private respondent for purchasing this house property. Now the loan became, once it became NPA, thereafter the petitioner came forward and.
You are a party to the writ petition, the entire thing has to go for mediation. If you choose to appear, you will appear, otherwise no.
But that is between the petitioner and the private respondent, husband and wife, my lord.
Yes, so what can I do?
My lord, in fact, the direction which has been sought for in the writ petition, if one's lordship sees, probably cannot be passed in the writ petition at the instance of the petitioner. There has been some default, but my instruction is, my lord, my client is here. He has paid, my lord, some EMIs. Even then, direction seeking on the private respondent to pay the EMIs at the instance of the petitioner probably in
This is a, there is a matrimonial dispute.
yes, that's a real dispute.
She has a claim to the, to your account in the bank.
My lord, she has a claim, my lord, there is a property purchased by the husband in the joint name of husband and wife. Entire money has been funded by them. They have a children, my lord. Some disputes, my lord, have arisen. Unfortunately, my lord, complaints have been made. Today, my client is not in physical possession. However, my lord,
Mediation is a best course.
absolutely, my lord,
Right, right.
absolutely. I hope it would be sorted out, my lord.
It transpires from the order dated May 11, 2023, passed by a coordinate bench that there was a chance of mediation in the matter, full stop. Today, comma, when the matter is taken up for hearing, comma, it is expressed by the petitioner, comma, appearing in person with the leave of the court, as well as the respondent number 2, that the matter be sent to mediation in order to resolve the issues between the parties. Full stop. In deference to such express intention of the parties concerned, comma, WPA 6032 of 2023 be sent for mediation before the appropriate mediators as approved in law, full stop. The registry shall take immediate steps for sending the file to the appropriate mediator for such purpose to enable the parties to undertake the exercise of mediation.
আমি একটা কথা বলতে পারি? বলছি, আমার যিনি উকিল বাবু ছিলেন উনি মানে একদমই সহযোগিতা করেননি শেষের দিকে, তো আমি চাইছি না উনি আর আমার এটা করুক, মানে উনি এখানে থাকবেন না তো?
মিডিয়েশনে ওনার না থাকলেও চলবে, আপনার চয়েস, আপনি নিজেও থাকতে পারেন।
আমি থাকতে পারি, আমার সঙ্গে অন্য কেউ থাকতে পারেন।
অন্য কাউকে থাকতে গেলে আপনাকে নো অবজেকশন নিতে হবে।
তাই উনি তো দিচ্ছেন না। আর মানে
উনি যদি না দেন নো অবজেকশন, আইনত আপনি একটা চিঠি দিতে হবে রেজিস্টার্ড পোস্ট উইথ এডি করে
দিয়েছিলাম,
ওনাকে, রেজিস্টার্ড উইথ এডি করে, যাতে এডি কার্ডটা ফেরত আসে আপনার কাছে। তাতে আপনি বলবেন আমি আপনাকে দিয়ে চালাতে চাই না, আর সাবজেক্ট টু ওনার ফি আপনাকে ক্লিয়ার করতে হবে তার আগে।
আচ্ছা ওটাই বলি, আমি
ওটা
মামলাটা
ক্লিয়ার না করলে ওটা হবে না।
না না আমি বলছি ওনার কোনো ফিজই আমার সাথে উনি আমাকে 7,000 টাকা নিয়েছিলেন আমাদের লোকাল, এবং
না আমার অত দরকার নেই। হ্যাঁ, আমি আপনাকে বলি, আপনি রেজিস্টার্ড পোস্ট উইথ এডি করে পাঠিয়ে দিন, এডি কার্ডটা ফেরত আসবে, সেটা প্রডিউস করবেন মিডিয়েটরের সামনে, সেটা নো অবজেকশন এর ট্রিট হতে পারে, কোনো অসুবিধা হবে না। আপনি
আচ্ছা আমি পারবো তো?
পারবেন,
উনি
পারবেন।
হঠাৎ 14,000 টাকা চাইছেন, আমার পক্ষে দেওয়া সম্ভব?
My lord has kept the writ petition pending, my lord. Disposed of.
Disposed of the writ petition, definitely. If the mediation fails, automatically it comes back. Should I record something in that regard? I'll put a line.
Liberty may be granted.
Yes, in the event mediation fails, comma, the parties are at liberty to mention for inclusion before the appropriate bench, then having determination. যদি মিডিয়েশন কোনো কারণে না হয়, আবার যে কোর্টে ডিটারমিনেশন থাকবে সেই কোর্টে মেনশন করে হিয়ারিং করতে হবে।
I'm grateful.
Thank you. Yes, Colonel.
Item number 17. Your lordship, in item number 17, Mr. Rupan Dev is appearing on behalf of the petitioner, your lordship, but due to the sudden illness of her mother, of his mother, he could not able to come to the
Yes,
court,
what
your
do you say?
lordship.
I am for the respondent number 4, my lord, point from authorities, my lord.
So when should I keep it? Both of you should.
Your lordship can keep it on tomorrow, your lordship. He has instructed me. On morning, I have.
Tomorrow is all right for him?
Yes, yes.
He has for the petitioner.
He is for the petitioner. Rupan Dev is for.
Acha, an adjournment is sought on the ground of absence of learned counsel for the petitioner on personal grounds. Full stop. Let the matter stand adjourned accordingly till tomorrow. All right, your lordship. Please give your name also.
Number 18.
My lord, I appear for the petitioner.
Yes, Mr. Doctor.
My lord, challenge in the writ petition is, my lord, a request for issuance of a lookout circular.
I release on personal grounds.
My lord, here, my lord,
Government will issue a lookout circle against me now. But that will be safe because I don't use
I
my
am sure
passport.
the judgment delivered by your lordship today morning also, my lord, comes in aid of this petitioner, though my lord was pleased to, my lord.
No,
give
now
a
I'll
short
start
stay.
rejecting your matters, Mr. Datta. Otherwise, I cannot
lord,
stop
here
the flow.
There is no, this was moved, my lord, earlier when
Banks are
lordship,
suffering for
when
this.
lordship did not have the
They cannot
determination.
recover. You are escaping, and they're not even getting the. I mean, no money, nothing. You're escaping
And I'll
with the
just
blessings of
try and indicate, my lord, that they don't fit in the, my lord, provisions of the consolidated guidelines. I just need to indicate that. My lord, the only ground taken is that you are a willful defaulter. My lord, despite directions for affidavit initially, my lord, when this matter was moved, my lord, there was an urgency, my lord, in as much as, my lord, there was a family wedding for which the family was traveling outside.
Yes.
My lord, one incident happened, one of the petitioners out of the three with his wife was traveling, he was, my lord, stopped. From there we come to know. We write letter to the bank, my lord, the bank says, I cannot, but you are a willful defaulter. I cannot disclose the grounds on what basis I have requested the issuance of LOC. Now, my lord, interim order was passed on the basis, we were allowed to ultimately travel because of the wedding, on the basis of, my lord, three separate individual undertakings in the form of affidavit, pursuant to an order passed by a coordinate bench. So, my lord, that is over now. My lord, I am today, my lord, at the final stage, my lord, no affidavits, despite direction, my lord, being issued on 12th of April 2020.
You're for the bank.
Have been
Yeah,
filed.
for the bank, I supposed to put my affidavit in opposition. What my learned friend is submitting before your lordship, one thing is scam. Money, the two writ petitions simultaneously has been filed. One in original side, one in appellate side. The reasons for issuance of LOC was that the petitioner was a willful defaulter, and that declaration as way back in the year 2018. And that was the reasons in view of the memorandum of office memorandum of Ministry of Home Affairs is one of the clause over there. If any person is a willful defaulter, the bank can issue a LOC. Yes, your lordship, I am having. So on the basis of that, the bank has issued an LOC.
Only show me that.
Lordship, I'm showing you, lordship. I'm showing. I am having.
Office memorandum of 2021 is the last one.
No, office memorandum 1918, 19.
2021 is the last one that has consolidated.
The last one where the LOC is will in
Apart
effect.
from the authorities, everybody knows that.
Yes, your lordship.
That 2021 is the last one.
My lord has a copy of that.
Only the authorities probably don't know as yet.
Authorities as in the immigration
Apart
authorities.
from the immigration authorities, everybody knows that 2021
No,
is
by
the
this
last.
time bank knows. And my learned friend, possibly he is missing on that. He is also aware, my lord. Because we, my lord, placed this. Mr. Bhattacharya was appearing for immigration authority. He placed this, my lord, again in a sealed envelope saying.
You
that
let
it
us
was-
see this. Yes.
Lordship. So lordship.
You give me the 2021 one.
My lord, I give.
Yes. Keep several copies, one bound on your wall.
Lordship, may I have a 2021 so that I
My
can.
lord, that is a 2022. This is the 2021 which lordship considered in the last.
2022 has also come.
Yes.
The 2022 with regard to LOC will be in effect until it is withdrawn by the original.
For that, right. Yes.
Lordship, I'm referring to 22nd of November 2018. Your lordship, kindly. The office memorandum of the Ministry of Home Affairs.
Yes.
Your lordship, if I am reading your lordship, the clause 3.
Please.
Clause 3. It is required that the instructions contained in MHS OM dated such and such, which the heads of public sector banks have now been empowered to issue requests for opening of LOC out circular may be strictly complied with henceforth, so that all the persons, your lordship, this is the important, all the persons who are covered under the said amendment office memorandum Ministry of Home Affairs, including fraudsters and the person who wish to take loan and willfully default or launder money and then escape to the foreign jurisdiction to avoid paying back and are restricted from escaping from the country. The Ministry of Home Affairs performer to issue LOC is inclusive. So this office memorandum has not been challenged, and view of this office memorandum, the bank has issued, and by this office memorandum, let's see, public sector banks have been empowered.
Yes.
Earlier, the public sector banks has not been empowered to issue LOCs, or that can only be issued by the authorities. But subsequently, why this come, your lordship, kindly, if I submit your lordship, after Jai Mallya and Nirav Modi's case.
Jaimalya.
Lordship, sorry, Lordship. Lordship, Nirav Modi and
Having spasms.
Vijay Mallya.
Having
I-
spasms.
Lordship, I
The
tender
B before Jai.
tender apology, your lordship. So lordship, because of that, in order to control this, and the willful defaulter declaration as way back in the 2018 has been challenged before the another writ petition.
Right.
They aware that the willful declaration if goes, this writ petition will be succeeded because the only basis of the issuance of LOCs was willful declaration. The present outstanding is more than 100 crores. So what was the outcome? Your lordship, that writ petition, I have occasion to appear before Honorable Justice Bhattacharya, and Honorable Justice Bhattacharya was pleased to
I'll
dismiss.
place, my lord, everything, my
Your
lord. I
lordship,
have the
pleased to
orders.
dismiss the said writ petition.
I have to indicate, my lord.
Your lordship, pleased to dismiss the said writ petition on the ground that the filing of this writ petition, the writ petition being WPO number 193, is nothing but an afterthought process to frustrate the process of willful declaration, which is barred by delay, laches, and acquiesces.
Let us come to that part of the observation.
Lordship. Paragraph number 6, your lordship.
Yes.
Page 3, as pointed out on behalf of the respondent back that the immediate cause of filing the writ petition is a request made by the bank to issue LOC against the petitioner in the month of August 2002. The lookout circular was finally issued in the month of December. The petitioner has filed a writ petition on 6th of March 2023 challenging the said lookout circular, and the writ petition is pending before this court. This court considered the matter and the grave interim relief to the petitioner on such and such date. It is therefore evident that the petitioner woke up from their slumber after 5 years only by reasons of the issuance of lookout circular against them. Significantly, the challenge of the lookout circular has made in the appellate side jurisdiction of this court, and the ground taken for such was that the appellate need to travel Southeast Asia on account of wedding in the family.
No, that was a challenge against the willful defaulter show cause.
Willful defaulter so cause. Lordship, that was the so cause
That was a
notice.
different challenge.
Lordship, I'm coming.
Yes.
Lordship, initially 2 writ petition was filed. The writ petition which is before your lordship, and this is the separate writ petition simultaneously.
There it was held by
Here it
Justice
was-
Bhattacharya that
yes.
they woke up from the slumber after 5 years to challenge the show cause of the willful defaulter
Yes,
when their lookout circular was issued.
was issued.
But that logic does not apply to the lookout circular because
Lordship.
that was the cause of their slumber breaking.
Yes.
So their slumber broke, immediately they filed this challenge against the lookout circular.
That is with regard to
Their slumber was fatal for that matter. regarding
that
the show-
matter.
Rightly,
The
so.
reasons rightly held. This order has been challenged.
Rightly because not challenged in appeal.
No,
Yes,
challenge
challenge
in
in
appeal, I
appeal.
lost.
Lordship,
right,
challenge in
it
appeal.
remains right.
Even challenge in appeal, the division bench has said, no, you being a willful defaulter cannot ask for any constitutional right.
Definitely.
That has been dismissed. Lordship,
Cannot
now
ask for any constitutional right. The appellate means held that.
no, that is not so, but the appellate court has said that there is no infirmity in the order passed by the single bench
Very well, yes.
regarding
So that was upheld.
that was upheld.
Very
Now, what was the reasons for issuance of
My lord,
LOC?
the appeal is
Admittedly,
pending, my lord. My
Your lordship,
stay, prayer
admittedly,
for
the
stay was
reasons-
issued.
Anyway,
so lordship, admittedly, reasons for issuance of LOC was willful declaration, and willful declaration has been challenged, went up to the appeal, lost. So the basic reasons for
there
LOC
have been, that was a challenge to the show cause. That was a challenge before Justice Bhattacharya. It was a challenge to the show
regarding
cause.
willful declaration.
Quashing of a show cause.
Not so cause, your lordship. That was for
Your
final order of willful declaration.
The judge held in the first sentence, the petitioners seek quashing of a show cause notice dated such and such and an order dated Achaveri.
Yes, it has been published. Everything has been
Right.
done. So the entire process of willful
So
declaration
now they are declared to be
declared to be a willful defaulter as way back in the 2018, finally come in 2019.
right.
And the basis of reasons for issuance of LOC against the petitioner, they are a huge defaulter, willful defaulter, as the memorandum, office memorandum handed over your lordship, which empowered the bank to issue LOCs in exceptional cases where the borrowers are willful defaulter. Here, the willful declaration is admittedly they have been declared as a willful defaulter. Went up to the division bench, upheld by the honorable division bench, no. Rightly upheld by the coordinate bench of the honorable court. So, lordship, my submission before your lordship would be the contention of the petitioner before your lordship is that they are the citizen of India. They may not, they are entitled to go abroad. They are constitutional right. But to answer to that, your lordship, my submission before your lordship is that we being the financial institution, public sector banks, holding public money, banks funds are raising from public money. Even in rupees of 1 lakh, the deposits of small depositors are there. So the interest of public at large cannot be superseded by the individual constitutional right who is a willful defaulter. And moreover, the office memorandum, as I have handed over to your lordship, is empowered the public sector banks. That is why, lordship, how much amount is decremental to economy of India has nowhere been defined. And if your lordship, if a litigation of, if they multiply such litigation into 100, the amount certainly come which will hit to the economy of India. If every individual by defaulting money to the public sector banks, and if saying before the court in the taking undue advantage of law that kindly protect me, I am entitled to. What about the constitutional rights of the public at large who had deposited their money to the public sector banks? I'm putting this question to myself, your lordship. So my submission, the public interest at large cannot be superseded by an individual, particularly who is in a willful default. And admittedly, in the writ petition, into the maximum 70% of the writ petition is talking about the willful declaration, which has been challenged in separate proceedings. Upheld by the Division Bench of Calcutta High Court, no. You have been declared as a willful defaulter, you slip over the issue for a considerable of 5 years, only come to the court after issuance of LOC. You are not entitled to get any protection regarding the declaration of willful declaration. And under such circumstances, I am putting this question to myself. Can a petitioner say that my constitutional right is curtailed because I am not allowing to travel abroad, I have a right of business? And if you have a right of business, why you are not thinking about the repayment of dues of the bank? And moreover, your lordship, from the record, your lordship will find another issue that the petitioner is a willful defaulter by conduct. They have not repaid the bank's dues, but arranged the ceremony of their daughter in Thailand. Matter of record.
Remain unmarried because they have not.
that marriage. I'm not
given
on
the
that.
daughter in marriage, so what?
No, that or a marriage, my submission, your lordship, would be for arranging a marriage in the abroad, funds required. On the one hand, you are not repaying the public dues, public money.
No, that I fully agree with you on that. On principle, yes. But whether we can cut short their liberty, as which you are passionately arguing against.
If such being the so I'm restricting to that.
No, we have to restrict ourselves to the office memorandum, which is binding.
Yes.
It has the force of law.
Yes.
You show me, you have shown 2018 office memorandum. This is not an office memorandum. This is a communication quoting the office memorandum and stating that so that lookout circulars may be strictly complied with henceforth.
Well, also 2019 is also there, maybe. If not, I'm
1921, 22 are there also. They substantially are the same, but without this willful defaulter.
But lordship, kindly consider the office memorandum 2022 or 2021. Nowhere it has been stated that a person who is in willful defaulter be at liberty to go abroad.
Constitution says.
Per contra, per constitution, lordship, that then lordship
Constitution says that.
Lordship, kindly allow.
You have to go against. If you have to go against that, you have to put something in the law.
Let's put something. Lordship, kindly appreciate the lordship subject to correction, your lordship, and obviously subject to approval, your lordship.
Yes.
And lordship has also looked into the this point that can a constitutional right of an individual. I'm arguing in this way. A constitutional right of an individual can prevail over a constitutional right of a public at large.
Public at large don't have any constitutional rights.
Lordship, the public money, lordship, kindly.
Public comprises of individuals who have their constitutional rights.
Yes.
Public at large is a bull with no eyes to see.
Lordship, if kindly allow me to make in this way, in this fashion, your lordship, every individual
constitutional right of one person against so many persons.
Yes.
There are small scale investors also.
Yes.
The bread and butter of the Indian society.
Yes.
It's their interest pitted against this person.
Lordship.
You are right on that.
Yes.
No disagreement on that.
Lordship.
But the difficulty is how far they can, how far you can override the rights given to them being a bank. You have to be bound by the office memorandum.
So I am bound by the office memorandum 2018 and 19.
All of us are bound by the office memorandum because those have the force of.
Yes. But the fact remains, your lordship, 2018.
You are representing the immigration authorities.
Yes.
Do they know that willful default is also one of the grounds? Declaration of willful default?
Yes, yes. During the
I'll
process.
hear the immigration authority.
Lordship, so my submission before your lordship is there. Lordship is also with me on this point, subject to your approval,
No,
lordship.
no, otherwise principally yes, but the memorandum does
But the
not say.
memorandum, your lordship, which I have handed over to your lordship, if your lordship kindly 2019 clause 2, even clause 2, also it talks about accordingly the Department of Financial Services.
Have you got a copy of the 2022 extra copy? Please check up. If you have, please hand over to your lord.
Yes.
Please just go through this. The same paragraph which is you are referring to, that has been considered here also.
Lordship.
Please just look through this. Para 2 says the same clause is there,
Yes.
including fraudsters and persons to whom it is preceded by, in this regard, reference is invited to Department of Financial Services, letter dated such and such 2018, the letter you are relying on.
Lordship.
That was written to all PSBs, informing that the heads of PSBs had been empowered such and such, DFS had advised such and such. Accordingly, the last sentence of that paragraph is, willful defaulter is there as here. Accordingly, various banks would have from time to time issued requests for opening of LOCs. Now then clause 3 comes in. MHA has now emphasized that the documents related to LOCs are classified in nature. So this is on this, in addition to sharing of code. Now, then the office memorandum has been reiterated here. The office memorandum nowhere speaks about willful default. The communication, because this 2022 communication also says that that was a Department of Finance circulation among its interested members or whoever, or to PSBs, that was informing about the office memorandum. That was not the office memorandum. The one which you placed to me, that is that circulation of the finance department, quoting the office memorandum. It was not the office memorandum. And the office memorandum does not say anything about willful defaulter. That is the difficulty.
Lordship, 2018, 18th of April 2019 memorandum.
Yes.
Is talking about office memorandum subject empowerment of heads of public sector banks to issue LOCs.
Right.
Why public sector banks? If such being the Lordship, kindly allow me 2 minutes.
I've allowed you much more.
Lordship. If had it been the case that the office memorandum is not talking about a willful defaulters from escaping their to business or go abroad, then certainly this office memorandum will not be empowered to the bank to issue LOCs. With certain intention, this language has been used, the office, why public sector banks will issue. The court has to also, Lordship, we have to also consider into this, why this power has been given to the public sector banks. I am putting this question to myself. The answer would be, according to me, Your Lordship, certainly to stop the fraudsters who, as a willful defaulter, admittedly the petitioner is, to escape from avoiding crossing the boundary of nation. And so far as the public interest as large is concerned, Your Lordship, or individual constitutional right is concerned, Your Lordship, my submission before Your Lordship in another way of submission, that every individual who are making their deposit before the banks or public sector banks, having savings money from their bread and butter and keeping the money in the banks from there where the bank is financing to the petitioner or the borrowers, will also be prejudiced. So the court has to also look into, if the petitioner wants to go abroad, let them pay the dues. On the one hand, they are not repaying the public money. On the other hand, they are taking the shelter of the constitution and asking, kindly allow me to do the business. How far it is acceptable? Can such defaulter be allowed to take shelter of court where they are admittedly in default of a public money and asking for me? Can you allow the petitioner to go abroad for their constitutional right in the garb of constitutional right? My answer would be no. If you are so bona fide, then you have to show your bona fide. You cannot enjoy constitutional right being a defaulter or being a non-compliance of the public interest.
Yes, let us hear the immigration. Yes.
But I had already indicated, my lord, the stand of the Bureau of Immigration, my lord, in the other case, which was extensively heard by your lordship.
You don't have much scope of movement in the joints.
No, but it's more like, my lord, we receive the request, my lord, on the request being received, my lord, we issue, my lord, the LOC. And in terms of, my lord, the 2021 guidelines, my lord, which I had placed, my lord, extensively before your lordship, my lord, but the liability lies on the originator, my lord, to explain, my lord. We have issued the LOC, my lord, whenever, my lord, it is presented at the time of immigration, my lord, the computer, my lord, screen there, it pops up there, my lord, that there is an LOC. And we take action in terms of, my lord, whatever the request is contained in the LOC, my lord. So that is there, my lord.
Yes,
And
the petitioner, what do you say in reply?
My lord, kindly takes, my lord, my petition to my lord office memorandums, because lordship has rightly pointed out to my learned friend, my lord representing the bank, that this is only a communication, the 2018 document, and not an office memorandum. Lordship, the office memorandums were being superseded time to time, and the 2021 document is a consolidation of all the office memorandum. My lord, I may draw my lord's attention to only the last guideline, 2021 guideline. Lordship will not find willful default being a ground for the purpose of making a request to the authority, the originator making a request to the Bureau of Immigration to, my lord, issue a LOC. If that is not a ground under the office memorandum, starting from 2010 office memorandum till 2021 consolidated guidelines, my lord, this entire basis of his argument should, my lord, fall. My lord, kindly takes only one document from the writ petition, how he had requested, my lord, for issuance of lookout circular. Page 60, my lord.
Yes.
My lord, this is in response to my letter when I was stopped. My lord, I had written a letter to the authority, my lord, at page 59, asking, my lord, information why I was stopped. My lord, then, my lord, in response, this was written by the bank. This has reference to your letter dated so-and-so received by us and so-and-so. In this regard, we wish to inform you, based on the classification of account, Messrs. SABYASACHI so-and-so, this is the, my lord, company in which we are the suspended directors. You as willful defaulter, lookout circular has been issued by Bureau of Immigration. So the only ground is, my lord, willful defaulter, classification by the, my lord, bank. My lord, they rely upon the writ petition order passed by Justice Bhattacharya, my lord, dismissing my writ petition. Lordship has seen that order. It was only on the ground of delay, 5 years delay, that it was dismissed. My lord, we preferred an appeal. My lord,
appeal pending.
Appeal, yes.
Interim refused.
So, my lord, the submission was possibly not correct that I have lost in the appeal. Interim was refused only again because of the delay. And the division bench felt that the learned single judge was right in refusing relief to me. Now, this issue will be considered as and when, my lord, the division bench hears out the appeal. I am not saying this presupposes that the willful defaulter order is stayed or something like that. But, my lord, it is still at large. Issue has to be decided. And why, my lord, this was done? If you, I have annexed, my lord, that order of the willful defaulter committee also. My lord, the review committee and the identification committee passes one single order, which is not permissible under the, my lord,
I won't go into
prudential
that.
norm.
I won't go into that.
No, lordship need not. I don't even want an observation on that. Just to satisfy your lordship, my lord, I only wanted to indicate this document to justify that the action of the bank in declaring willful default, my lord, identification committee first declares willful default, and then, my lord, the review committee approves that. Within a gap of 15 days, I need to apply before the review committee.
Yes.
In this case, what had happened was the order, the communication is both by the identification committee and the review committee. Hence, we feel, my lord, in the appeal, my lord, we may have a chance. Now, my lord, on
I'll pass my order.
lookout circular, my lord, I
Then
just wanted to
counsel for
rely on Vishambar Saran again, my lord.
The counsel for the petitioner contends that the lookout circulars issued against the petitioners are dehoards the law, comma, having been issued on the ground of the petitioners being declared to be willful defaulters, comma, which is beyond the grounds envisaged in the concerned office memoranda. Full stop, next para. Learned counsel appearing for the respondent number 2 bank places reliance on communication dated November 22, 2018 by the Deputy Director within bracket BOII bracket closed, Government of India, comma, Ministry of Finance, comma, where it was mentioned that the heads of the public sector banks were empowered to issue requests for opening lookout circulars, comma, which may be strictly complied with henceforth, comma, so that all persons who are covered under the amended OM of MHA, comma, including fraudsters and persons who wish to take loans and willfully default or launder, LAUNDER, money and then escape to foreign jurisdictions to avoid paying back, comma, are restricted from escaping from the country. Full stop. Next para. Learned counsel appearing for the bank makes an impassioned plea on behalf of the common citizens of India, comma, who place their trust in public sector banks but suffer due to defaulters not repaying the amounts of loans taken by them, comma, who seek to flee the country. Full stop. Next para. Learned counsel for the bank also places reliance on an order passed on a judgment of a coordinate bench passed in WPO 193 of 2023, comma, arguing that a similar challenge was turned down by the said learned single judge. Full stop. Next para. Learned counsel appearing for the immigration authorities contends that the role of the immigration authorities is limited and the liability primarily lies on the originator regarding the request for issuance of LOCs.
May I just add, my lord, two things, my lord. First is, my lord, the Ministry of Finance, my lord, is not a party here, my lord. Since, my lord, so
And what is the other thing?
the other thing is, my lord, in the amended guidelines, my lord, an act which is prejudicial, my lord, to the economic interest of India, my lord. In those cases also, my lord, LOC can be
Yes,
issued.
that is there. Full learned counsel for the immigration authorities further submits that the Government of India through Ministry of Finance is not a party to the present writ petition. Full that apart, comma, acts detrimental to the economic interests of India also furnish valid grounds for issuance of LOCs. Full stop. Next para. Heard learned counsel for the parties, full stop, the reliance placed by the bank on the coordinate bench judgment in WPO 193 of 2023 is misplaced in the present context, comma, since the same was in the context of a challenge against the show cause notice issued for willful defaulter and the subsequent order declaring the petitioners to be willful defaulters. Full stop. The learned single judge proceeded on the premise that the petitioners woke up from their slumber after 5 years only by reason of the issuance of the lookout circular against them and challenged the show cause notice and the willful defaulter declaration. Full stop. On such ground of delay, comma, the writ petition of the petitioners was rejected. Full stop. Against such dismissal, comma, an appeal has been preferred which is now pending. Full stop. However, comma, the petitioners failed to obtain any interim order therein, comma, also primarily on the ground that the petitioners had occasioned a huge delay in preferring the said challenge. Full stop. Next para. The challenge in the said writ petition is, comma, however, to the declaration of the petitioners as willful defaulters. Full stop. The present challenge is against issuance of LOC, comma, on the request of the originator bank, comma, apparently on the ground of such declaration of willful defaulter. Full stop. Since the petitioner's previous writ petition stands rejected as on date, comma, this court cannot and does not intend to go into the merits of such willful defaulter declaration, comma, since as of today the willful defaulter declaration stands against the petitioners. Full stop. Thus, comma, proceeding on the premise that the petitioners are as of today, comma, willful defaulters under the relevant circular of the Reserve Bank of India, comma, the present adjudication is taken up. Full stop. Next para. Even a first glance at the communication handed up by learned counsel for the bank indicates that the same is not an office memorandum itself, but is a communication dated November 22, 2018, comma, by the concerned official of the Ministry of Finance, comma, Government of India. Full stop. The said communication was, comma, in fact, comma, referred to in a further communication dated April 8, 2022, comma, which is handed up by learned counsel for the petitioners and reiterates the contents of the 2018 communication. Sorry. Full stop. However, comma, from both the communications, it is evident that the expression double inverted willful default was an expression used by the Ministry of Finance in its communication, but has not been specifically stipulated as a ground for issuance of LOC. Full stop. Apart from cognizable offenses existing against the person concerned, comma, there are certain grounds which are stipulated in the concerned office memorandum in exceptional cases, comma, which can at best, comma, govern the present case. Full stop. The only grounds therein which might have arguably applied to the petitioners are that the departure of the petitioners would be detrimental to the strategic and or economic interests of India, and if such departure is permitted, comma, the same would be contrary to larger public interest at any given point of time. Full stop. Next para. Declaration of willful defaulter is not envisaged as one of the grounds of the office memorandum. Full stop. The said declaration is a means adopted by the Reserve Bank of India, comma, in its affairs, comma, within the scope of the statute governing the RBI, comma, to give sufficient notice to all concerned in the commercial sphere regarding the antecedents of particular borrowers. Full stop. Next para. The said circular operates in its own field and cannot be imported as a ground in the office memoranda issued by the Government of India for the purpose of issuance of lookout circulars. Full stop. Willful defaulter declaration has limited connotation, comma, pertaining to the economic activities of the person concerned and has no bearing on the issuance of a lookout circular. Full stop. Next para. Insofar as strategic and or economic interest of India and or larger public interest is concerned, comma, there is nothing in the materials on record to indicate that those grounds were pleaded or details regarding the said grounds were furnished by the bank in its request for issuance of LOC in the present case. Full stop. The only admitted ground for the request was that the petitioners have been declared to be willful defaulters under the relevant RBI circular, comma, which is not a valid ground for issuance of lookout circulars. Full stop. Hence, comma, within the limited conspectus of the present writ petition, comma, I find that none of the grounds contemplated in the office memoranda for issuance of lookout circulars is satisfied with regard to the petitioners. Hence, comma, the issuance of lookout circulars is vitiated in law and dehors the office memorandum of the government itself. Full stop. Next para. Accordingly, WPA 5778 of 2023 is allowed, comma, thereby setting aside the lookout circulars issued against the petitioners. Full stop. The respondent authorities shall ensure that the petitioners are not restrained from leaving the country on the premise of the impugned lookout circulars in future, and to ensure that all authorities which were intimated by the respondents about the issuance of such lookout circulars are re-intimated as to the quashing of the same at the earliest, comma, preferably within 3 weeks from date. Full stop. No others to cause adjustment.
Grateful, my lord.
Well argued.
My lord, before rising.
Yes, Mr. Chatterjee.
Grateful. My lord, this is the recruitment for the post of ICDS program, my lord, in the Hooghly district. My lord, initially the advertisement was there. We have applied for, and there
What are you
was,
wanting now, Mr. Chatterjee?
my lord, only praying for leave on that very occasion, because not considering our
Leave for?
leave to move this application tomorrow, if your lordship please so. Because I have been instructed tomorrow is the last date of submission of the application. By not considering our cases, they are again going to initiate another new recruitment process, my lord.
At a leave the event tomorrow 10:30.
I'm grateful,
Tomorrow
Lord.
10:30.
I'm grateful, lordship. I'm grateful.
Your matter.
My lord, I
Kamala
have-
Kali Agro
Appear for the respondent, my lord, respondent bank.
was for the petitioner. No, this was mentioned to be taken up at 2.
Possibly, my lord. We have received notice to that.
Right.
Krishna Kamla, my lord, agro.
Yes.
My lord, the short point involved is that if my lord may kindly consider two annexures. my lord. May I respectfully place page 70, my lord.
$70.
70, my lord.
Yes.
Well, this is a letter dated 4th of September 2023, yesterday.
Right.
And kindly consider the first paragraph, the last line, where they say the date for taking physical possession of the mortgage property has been fixed on 5/9/2023 today. Well, this is the action which they are taking without giving me adequate notice of their arrival, and the action which is sought to be taken is as draconian as physically dispossessing me
Who
from
are
the
you?
property.
What is your
I'm the
purpose?
borrower. This is my property, I'm the borrower. And number 2, my lord, I am precluded by sufficient cause that even the tribunal who is in session of the matter, where my section 17 is pending, that bench is vacant. If my lord may consider page 69, which talks about my SABYASACHI application pending before the Debt Recovery Tribunal, and my lord may kindly consider the second table. Next listing date is 19/9/2023. So my lord, even I cannot go before
When did you file it?
my lord, that was filed in 24th of September 2019.
Right. Why didn't you do anything regarding that? No
Yes, my
interim
lord,
order,
this was a valid question. I was in, my lord,
waited for this 14th section.
no, my lord,
Now
what has
this is not
essentially happened that after I filed, I was protected by way of an interim order. March 2020, COVID hit. Till 2022, my lord, the courts were only hearing put up application. They were not taking hearing matters. And my lord, after that, on and from July 2022, the regular judge retired. And thereafter, matters were apportioned to a court in charge who was hearing only the put-up matters. Well, and in short, from 2020 onwards till date.
File an interim application. You say you were enjoying an interim order.
Yes, my lord.
What happened to that?
Well, that is still pending. All of those are pending. My SABYASACHI application
Interim order is subsisting.
No, my lord. Interim order, which initially was granted, was not continued thereafter. It was not vacated, but it was not continued.
You did not pray for extension.
Well, that was only because the courts were not taking. I did not mention COVID issues. All taken together was the difficulty. But my lord, the point is,
chose not to move for extension of that matter. Now at the 11th hour.
my lord, may kindly consider page 71 once.
71, yes.
Yes. My lord, this is the notification by virtue of which the charge was given to the Debt Recovery Tribunal, Siliguri. The matter is pending before DRT 2, Kolkata. And my lord will find that it clearly says, my lord, kindly consider
For a period of 6 months.
5th line, my lord. The additional charge of the post of the presiding officer of the Debt Recovery Tribunal for a period of 6 months with effect from 1/3/2023, which expired, my lord, on 31st of August. Now, my lord, the order which they are seeking to enforce essentially is, my lord, at page number 31.
So are you sure that this has not been extended? Must have been extended.
No, my lord, it's not extended. The bench is still vacant. DRT 2 matters.
Page 31.
Page 31. This is the order which they are seeking to enforce, passed on 17th of July 2019.
After this order, this was the first communication to you?
Yes, my lord. And my lord, the point of law as of now is that after this order is passed, my lord, they have to execute this order within 60 days of the order being communicated to. And that 60 days has long expired. It is almost after 4 years, my lord, a little more than 3.5 years that they are executing it. My lord, I am protected by.
60 is the outer limit, 30 plus 30.
My lord, that is for between the period when the application is made and the order is passed.
Yes.
My lord, Honorable Apex Court in the Seabright judgment has made it very clear. I am not placing that judgment, my lord, that the disposal of an application made on section 14 is directive, not mandatory. 60 plus 30, even thereafter they can pass. 30 plus 30, that can be passed. But after
What do you propose now? I mean, I can give you some time subject to hearing the other side. I can give you some time to approach the Siliguri tribunal.
my lord will kindly do that. I'll approach.
And
that.
I'll make it very specific that it has to take up when you approach.
Kindly, my lord.
My lord, question of alternative remedies, obviously, my lord, I will kindly come to
Give me
page,
just IB remedium.
my lord, page
Without
69.
any forum.
My lord, page 69, my lord. My lord, they have in fact taken steps out there. Possibly they have failed. Now they are coming up before this. Our humble submission is that the writ court's jurisdiction should not be used to that extent of interfering with steps taken in accordance with law as per the Securitization Act, my lord. My lord, we are permitted to do so. We have given a notice and we have proceeded with it.
I'll give them 4 weeks.
My lord, it's a proceeding of 2019. I have taken a
That
point.
is the reason.
My lord,
You were after 4 years.
my lord,
So 4 years and 4 weeks. I mean, you waited for 4 years. Now wait for 4 weeks.
my lord, but steps have been taken, my lord, in accordance with law. My lord, we kindly will set a bad precedent.
What steps?
My lord,
The section 14 and all these things.
yes, my lord.
Definitely, no doubt.
And my lord, will kindly see there's a limitation point which we have taken also.
Oh, yes.
And-
What is that?
yes, my lord.
Limitation point in the section 17.
Yes, I'll just indicate. My lord will kindly come to my opposition.
Yes.
Page 62 starts at page 63, my lord, para 5. That applicant has challenged the order dated so and so has been filed beyond the statutory period, as such should be dismissed forthwith. My lord, this point is also open, my lord. So in light of
Limitation in the section 17.
yes, my lord.
So that will always be there. I'll direct them to, I'll give them liberty to approach the Siliguri tribunal for interim orders.
My
If
lord.
they fail, they fail.
My lord.
This 14 will revive. 14 is already there, no
My
question of reviving.
My lord, I'll just take instructions.
Why did you wait for so long after 2019?
My lord, I am also, we are handicapped, my lord. The notice was served today itself. We just came hurriedly. Within half an hour back, we have been briefed in the matter, my lord.
My lord, they affixed yesterday in the afternoon and they left. It is
Actually, yesterday the notice was given that it will be,
My lord,
the position
possibly,
will be taken today.
my lord, there was, my lord, will kindly come to
Yes.
8, rule 8.
Yes.
My lord, I could not find anything which prevents me from doing so. Reasonable time, my lord, we are admitting page sale of rule 8.1 of the security interest enforcement rules.
subject to correction. The rule 8 has nothing to do with section 14 action.
My lord, but that's a point which has
pertains
been,
to sale.
they have taken a point of in the writ petition, my lord. 8.1, where the secured assets is in the author shall take or cause to be taken possession by delivering as possible in appendix 4 to these rules to the borrower and by affixing possession notice on the outer door or at such conspicuous place of the property. This is my format for my lord, will kindly come to appendix 4.
My lord, may I interject, my lord? 8182 is an exercise while they go ahead with symbolic possession. That is a subject matter of consideration by the tribunal in the section 17 proceedings. Section 14 and its implementation is altogether a different exercise.
No, you cannot be loud on that because section 14, once an order is passed, you are in jeopardy. And there is no further
My lord,
scope of any notice to you at all.
yes, my lord.
They were gracious enough to give you a notice.
There's authority one, Shipra Hotel says that the notice has to be given, at least giving the person adequate opportunity to either vacate or take appropriate.
Order was your notice.
And
Well, that order was not implemented. This was implemented by virtue of this. That order is a subject matter of section 17 also, till date.
No, section 14 application was decided by this order dated 17th of
Yes, my
July.
lord. And that is a subject matter of a list pendants before the DRT.
Not stay, my lord, nothing. My lord,
And now they are seeking to dispossess me on the strength of an order which was passed in 2019, which is
Nothing prevents them.
my lord prevents, my lord, kindly consider.
upon
It is
oral
within.
You're citing as yes.
Yes, my lord.
and
My lord, the principle laid down is Cassius Omnissus by the
I'll
his
hear,
lordship.
hear him on this and then I'll give you.
my lord, I should indicate, my lord, I've just received instructions. In fact, today they were in the process of taking possession. I'm orally instructed, my lord, that possession has already been taken. My my learned friend can kindly check up once.
একটা order record করো। Learned counsel for the petitioner contends that pursuant to an order dated July 17, 2019, under section 14 of the Surface Act 2002, the respondent bank gave a notice yesterday indicating that possession would be taken from the petitioners today. Full stop, next para. During argument, learned counsel for the respondent bank submits on instruction that possession might have been taken in the meantime. Full stop, next para. As such, the matter is being heard expeditiously. Full stop. A perusal of the documents show that the bank waited since July 17, 2019 for taking possession pursuant to the order dated pursuant to the order of event date, under section 14 of the 2002 Act, full stop. Hence, heaven will not fall if the possession is restrained, if not already taken, and appropriate orders passed against the bank. Full stop, next para. Moreover, learned counsel for the petitioner argues that at the present juncture, there is no functional alternative forum for ventilating the petitioner's grievances. Full stop, the petitioner's application under section 17 of the 2002 Act is pending since long and was fixed next on September 19, 2023. Full stop. However, since the regular presiding officer is absent in the DRT2 bench, where the petitioner's application is pending, the matters of the said bench were assigned to the Siliguri bench. Full stop. Yet, the said assignment was only till last March. Full stop. Hence, it is submitted that the petitioner is at present without any effective remedy. Full stop. Even without going into the grounds, even without going to the reasons for the inordinate delay on the part of the petitioner as well, in seeking extension of interim orders or obtaining fresh interim orders from the tribunal, since the petitioner does not have any forum at present, this court ought to assume jurisdiction under Article 227 of the Constitution, 226 of the Constitution of India, since the doctrine ubi jus ibi remedium is squarely applicable. Full stop, next para. In order to give some breathing space to the petitioner, liberty is granted to the petitioner to approach the Siliguri bench of the Debts Recovery Tribunal immediately for appropriate interim reliefs with regard to the secured assets. Full stop, next para. Upon such approach being made, the Siliguri bench shall immediately fix dates, preferably within 48 hours from the application being made by the petitioner communicating this order, for consideration of grant of interim orders to the petitioners. Full stop, next para. In the event the possession has not yet been taken, that is till the present moment, which is 2:12 PM, the respondent shall remain restrained from taking possession of the property for 4 weeks. Full stop, next para. In the event possession has been taken prior to the above mentioned time, the respondent shall remain restrained by an order of injunction from dealing, transferring, alienating, or encumbering the secured assets, including the movable property therein, in any manner whatsoever, also for a period of 4 weeks. Full stop. Such interim order, however, shall be subject to any interim orders which may be passed by the tribunal when so approached by the petitioner in terms of the above liberty. Full stop. It is made clear that it will be open to the concerned Debts Recovery Tribunal to independently decide the prayer for interim order in accordance with law without being influenced in any manner by any of the observations made herein, as well as to vary, modify, vacate, and or extend the said interim order, within the discretion of the said tribunal. Full stop, parties and all concerned shall act on the communication of the learned advocates coupled with a server copy of this order without any
My lord, only one submission, my lord.
WPA such and such is disposed of in the light of the above observations without any orders.
My lord, my lord, we are not filing an affidavit, so no allegations are admitted.
Since no affidavits were invited, comma, it is deemed that none of the allegations made in the writ petition are admitted by the respondent.
My lord, the charge was till August 30th. My lord has recorded
March
March,
বলেছি,
which will be
August, sorry, till the end of March বলেছি, ওটা August হয়ে যাবে. Thank you.
I'm grateful.
Take it back for better,
Yes.
I mean, use it for a better purpose. এই বইটা কি আমাদের?
Yeah. Grateful. Thank you.
Next.
Item number 19.
May it please your lordship, in this matter, my lord, I am appearing on behalf of the petitioner.
Right.
May I permit it to file my affidavit of service?
All have been served?
All as, just, my lord.
Yes.
The respondent number 4.
Yes.
Avoid the service, my lord. Okay, last one, my lord.
Acha. Now, item delivery confirmed. Oh, one is insufficient address, it says.
No, my lord, all are, copy the all are signed in the same address, my lord.
How are they related, the respondents?
Son of the petitioner. They are living in the same place, my lord.
Son of the petitioner?
Yes, my lord.
Acha, yes.
He is torturing the parents, aged parents, my lord, to transfer the property in their name, my lord. And my lord, the petitioner is 74 years old.
You have the Senior Citizens Act in your favor.
Yes, my lord. Yeah, that's why, my lord, the petitioner on June 7, 2022, made an application before the subdivision officer Boshirhat, praying for seeking administrative assistance as per Maintenance and Welfare of Parents and Senior Citizen Act 2007. Thereafter, my lord, all the conciliation officer was appointed. He took the evidence of all the parties, and the report which is filed is what I say is a arbitrary report, my lord, because the mother petitioner never asked for any maintenance. She wants the son, and he's living with his family, torturing the aged parents, should leave the house because she is the owner of the house, my lord. And my lord, after the order of the maintenance tribunal, she challenged that order. The appeal is pending before the respondent number 2. Now I came before your lordship. Kindly direct the respondent number 2 for early disposal of that appeal.
Definitely. When did you file it, please?
On 11/22, my lord, November 22. The appeal was filed. Your lordship, kindly come.
Despite service, none appears for the respondents. Despite substantial service, comma, none appears for the respondents, full stop. In view of the innocuous nature of the prayer made, comma, further service is not directed. Full stop. Next para. The petitioner is a senior citizen and made an application before the concerned.
It's page number 13, my lord.
SDO against the Maintenance and Welfare of Parents and Senior Citizens Act, 2007, which was decided, full stop, however, being aggrieved with the said decision, the petitioner preferred an appeal against the tribunal comprised of the district magistrate at Barashat. Full stop. However, the said appeal is still pending since November 2022. Full stop. The petitioner seeks an early disposal of the same, since the petitioner is of advanced years and is allegedly suffering torture from the private respondent. Full stop. Next para. In view of the implicit urgency involved in such matters, WPA 7359 of 2023 is disposed of by directing respondent number 2, the district magistrate, district North 24 Parganas, to decide the appeal preferred by the petitioner against the private respondent number 4 as expeditiously as possible, comma, positively within 6 months from this date, full stop. Next para, it is made clear that the above time frame is mandatory and peremptory and shall be adhered to by the district magistrate positively. Full stop, no arrest to cause urgent certificate. Thank you.
Not 20.
My lord, I am from petitioners.
Yes, please.
My lord, last day you directed to submit exchange affidavits. So I am submitting affidavit in reply.
Opposition has been filed?
Yes, my lord.
Right.
My lord, the petitioner is a society running one minority educational institute.
Right.
And through their property, the respondent wants to lay down high tension cable, which was challenged in this writ, my lord. My lord, the petitioner, being a minority educational institute, is covered under Article 30, which says, my lord, I am relying upon one judgment which I have annexed. This is Society of St. Joseph College versus Union of India.
Where is it annexed? Page?
My lord, I annexed the
which page?
India Kanun. So I am giving you a fresh judgment, my lord, from the Supreme Court website itself.
Thank you. Yes.
My lord, first page.
Right.
Article 30, a right of minorities to establish and administer educational institute. 1. All minorities, whether based on religion or language, shall have the right to establish and administer educational institution of their choice. Subsection 1A. In making any law providing for the compulsory acquisition of any property of an educational institution established and administered by minority referred to in clause 1, the state shall ensure that the amount fixed by or determined under such law for the acquisition of such property is such as would not restrict or abrogate the right guaranteed under this clause. My lord, in this judgment, the last but one page number 4, the court held, my lord, the last but
we cannot accept.
Yes, we cannot accept the submission of the learned Attorney General that the provisions of a statute that provides for the acquisition of property in general, as for example, the Land Acquisition Act, are adequate for compulsory acquisition of the property of minority educational institution, because what is payable therein is compensation, or that the provision for clause 1A of Article 30 should be read into such statute. Clause 1A clearly states that after the date of its introduction, there must be a law that specifically relates to the compulsory acquisition of the property of minority educational institution, and that the law must make provision that ensure that the amount that are fixed or determined thereunder for the acquisition are such as do not restrict or abrogate the right guaranteed under Article 30. Necessarily, such law must require to the taking into account of the factor that do not came into play in the determination of amount payable in relation to acquisition of properties of the other and are therefore not set out in general acquisition statute. And my lord, I want to rely on one more Supreme Court judgment.
So it says that the ordinary law of acquisition does not operate.
Yes, yes, my lord.
That argument was made by the Attorney General, not accepted.
It was not.
Has to be a specific statute contemplated. That has not yet been enacted.
No. And my lord, I want to come later on that they are doing all this thing under Act, the Electricity Act 2003.
Yes, 2003. Yes.
And they could take one ground in their counter affidavit that as this judgment was in 2001 and the act was in 2003, so it's don't have any play on that.
Constitution remains the same.
Yes, yes, it was. My lord, I want in that 2003 act there was no provision for acquisition of minority educational institute property.
So you say under the 2003 Act, minority institution run properties cannot be acquired.
Yes, yes.
One. Second aspect is in the present case, also another question arises whether this amounts to acquisition.
Yes.
Because they will take a point that this is not acquisition right of user.
Yes.
Which is the language used.
Yes.
Satisfy me on that also.
Yes.
Complete your this point, then come to that.
Okay. My lord, I want to share with you one Supreme Court judgment of Sidabji Bhai Sabhai and other versus State of Bombay and another. This is of 1962. My lord, in last page number 12. The last but first para, the right established by Article 31 is a fundamental right declared in terms absolute, unlike the fundamental freedoms guaranteed by Article 19. It is not subject to reasonable restriction. It is intended to be a real right for the protection of minorities in the matter of setting up of educational institution of their own choice. The right is intended to be effective and is not to be whittled down by so-called regulative measures conceived in the interest not of the minority educational institute, but of public or the nation as a whole. So they want to say, they said in their counter affidavit that public interest should be prevail over minority interest. It is not saying like that. It has to be, I can say further that it has to be balanced. Both interests should be balanced. My lord, they have taken one more ground that this will not an encroachment. I want to depend on two. One is West Bengal government policy and guideline for setting up private universities. The petitioner institute has applied for upgradation in university, which before the government of West Bengal, and the government of West Bengal has considered their pair. Here is the last communication, my lord, where the government of West Bengal has told them that clear the deficiencies so that we can go further.
Into annex it to your writ petition.
It was subsequent, my lord. It was 16/8/2013.
So did you annex it to your reply?
No. The reply I filed before that, my lord.
And give a copy to them and.
Yes. My lord, in this, the government of West Bengal has said regarding submission of compliance report for establishment of Dr. Bhattacharya St. Mary's Advanced Comprehensive Rehabilitation University. In the last line, my lord, hence I am directed to request you kindly to confirm whether the deficiency as mentioned by the committee stated above has been resolved. Your early response is solicited for taking further necessary action from this end.
So there was a deficiency.
Yes, my lord, deficiency in the terms of, selection of VCs and all. These are statutory obligations, my lord. It is a standard practice. They first visit. If they found some deficiencies, they send a letter. We have to clear. They then final inspection and they give the permission, my lord.
So this is not it. Your running of this institution as a minority institution, that is not yet final.
No, this is minority institution is
For
running.
what purpose?
No, this is for university. I am coming.
Oh, now you're wanting to be a
Yes,
university?
from 2011 we are running college.
Very, yes.
My lord, I want to depend on the West Bengal government's policy and guideline for setting up private universities.
Yes.
My lord, here in page number 5, point 6C. Point 6 is establishment of private university, page number 5, my lord.
Yes. 6C.
C. No applicant shall be permitted to establish a private university unless such applicant is in possession of contiguous land property having absolute title on it and free from all encumbrances not less than 7 acres in case of urban area. So this is
So you cannot establish a university if that is encumbered.
yes. And my lord, I am coming right now. We are running one private engineering college affiliated to MACAUT and approved by AICT. What AICT regulation said, my lord, my affidavit in reply, page number 20, my lord. Page number 20, my lord.
Yes.
Page number 90 says chapter 7 norms and requirement. 7.1.7D. Page number 20D. This is AICT approval process handbook. Plots of land under consideration shall be contiguous and shall have no obstacle such as river, canal, railway track, highway, high tension line, or any such entity hampering continuity of the land. In case if the obstacle came later, connectivity shall be ensured in proper safety certificate should be produced from the competent authority. We don't know who is the competent authority to issue such safety certificate. There is no guideline on that in AICT approval process handbook also. My lord, if after university, we will come under UGC regulation. UGC regulation, establishment and maintenance of standard of private university regulation 2003. In my counter affidavit, page number 23, my lord.
Yes.
Page number 25, my lord. Page number 23 start. I want to quote 25.
Yes.
3.4. A private university shall fulfill the minimum criteria in terms of program, faculty, infrastructure, facilities, financial viability, etc., as laid down from time to time by the UGC and other concerned statutory bodies such as All India Council for Technical Education, AICT. So if we converted into university, then also I come under AICT approval process handbook, which I showed already.
Right.
My lord, in their counter, they have taken out few points that 17 tower out of 20 tower was completed. This should not be a ground, my lord. That 20 out of 20 tower, 17 tower has been installed. So rest 3 has to be done.
It will involve huge costs.
Maybe, my lord, they have to take some protection.
When did you make the objection after the 17 towers were built? You took the objection after the towers were built.
No, when they came, they have diverted the line, my lord. Initially, it was not upon our land.
Whenever they came to your land, you took the
Yes,
objection.
they have not given us any notice also. On our own, coming from the local people, we have written them a letter. And in that against that letter, they have confirmed that yes, we are going to lay a high tension cable over your property, which was challenged. And my lord, they told that in newspaper we have given notification when you should challenge then only. My lord, in the notification, only Mouja was mentioned. And in a Mouja, there are hundreds and thousands of plots. So how could I know that it will go through my plot? They told that one university, Adamas University, high tension cable was passing through them, but they have not objected. I have countered it, my lord, in my affidavit that
is that a minority institution also?
No. That I have mentioned that first, they are not coming under minority, so they are not protected under Article 31. And furthermore, that the high tension cable, I personally visited the place, the high tension cable passing over their boundary wall, not like us in between the plots, bifurcating the plots in two sections. My lord, kindly see page number 83 of my writ petition. Their map is the high tension cable passing through my plot, bifurcating the plot into two building one side, one building one side.
Which is your campus? The
entire, my lord, the entire.
This is their map?
Yes.
WBSCD cell?
Yes, my lord.
Your writ petition should be allowed due to the spelling of Saint Mary.
My lord, it should be why, my lord.
Suppose your client loses on that. Anyway, then what else? Article 30, that this Electricity Act is subservient to the constitutional authority.
Yes.
One. Secondly, your practical difficulties, you cannot form an university and all the other aspects.
Yes.
You are a running institution there. Therefore, in any event, 30 applies.
Yes. And my lord, they told that the original line, there was residential building. So they should have seen all these things prior to take up this plan. When there is some obstruction came, they could not manage. So they came to us without taking our permission or anything else. On their own, they have decided all these things. And they have taken one more ground, my lord, non-joinder of necessary party. That is, in our campus, there is Skill Development Center run by Joseph Siharsa and Mary Indroja Educational Society, which is a director of this petitioner. And it is running short-term courses, only 3-month courses, and that is only a small part. So their interest will not be violated in this case. So we have not added them as party. That's all, my lord.
Right. Yes. Yes. Sir.
Argument of Manhattan, if I'm correctly understood.
Mr. Panja, take the microphone. Yes.
If I am correctly understood, sum and substance of this argument, my landman's argument is that as they are covered by under Article 30, so I cannot take it. Now, Milord, at first I will make my submission on Constitution. What is Article 30? And Milord, other fundamental rights. May I read, my lord?
Please.
Article 30. The right of minorities to establish and administer educational institutions. All minorities, my lord, very first 2 words, all minorities. I am on that, my lord. Why I am saying, my lord, I will come to other fundamental rights also. I will not read entire fundamental rights, that is from right from Article 12 to Article 39, but I will place only 2 or 3. All minorities, whether based on religion or shall have the right to establish and administer educational institution. I will not read more. So, my lord, I am emphasizing on all minorities. Now, my lord, I will place, my lord, the Article 30 minorities, my lord, is not absolute. Now, my lord, lordship, kindly, my lord, thereafter, I have so many times placed the judgment that Electricity Act is covered under Article 21 and all these things. Your lordship has held already. And
Electricity Act is Article 21 definitely, but that is with regard to right to get electricity under Section 43.
Yes.
All those judgments are in that perspective.
Yes.
Not on the right of the licensee to install a high tension.
Absolutely, absolutely. There is no court. Now, my lord, may I read, my lord? First, my lord, Article 1 of the fundamental rights, my lord, Article 19, my lord, may I read?
Yes.
Just two, 3 words I will read only.
Sure.
All citizens shall have the right. Just I will read only that. That means entire country. Applicable 19. Now, lordship, kindly come to 21.
'21 is wider, no person. Any person on the soil of India.
No person shall be deprived of his right. Means again, will not enter India. The citizens of India.
Not only citizens, even foreigners in the soil of India.
Yes.
Right to life definitely has to. Very well.
So, my lord, I will not read any other fundamental rights. Your lordship will find the same, all those words. You are only wasting the court's valuable
Not wasting, Mr. Bade, you have to deal with the Supreme Court judgments also.
Yes,
Your
yes.
learned friend produced, cited certain judgments.
I will come immediately. I will come.
Great.
Now, my lord, my lord, Article
the interest of all citizens and all persons versus minorities is on a lesser footing. I mean, shorter.
Yes,
Very
yes.
well.
This is
Yes.
my lord, this judgment. All right, my lord, let me deal with first Supreme Court
Because
judgment.
this is the precise point on which the Supreme Court.
Yes, my lord, may I say, my lord, get respect. This Supreme Court judgment, my lord, কপিটা কোথায় রে দিলেন না রিপিটিশন দিয়েছেন উনি যে কপিটা দিলেন my lord, this is with regard to the acquisition.
Yes.
Now, my lord, dear lordship is aware that under the transmission law of transmission, we have no right to acquire the land. That right has not been given to us. Only right that under the Telegraph Act, we are the user. Only right. We are the user, not acquiring the. So, my lord, we get respect, my lord, unnecessarily wasting the lordship time, my lord.
Mr. Maja, the acquisition, it is not acquisition right of user as per the Electricity Act. I can appreciate that. But in the cloak of an, I'll not say in the garb of a, that has a different connotation. In the shape of a right of user, if a high tension line is taken pat over the middle of a property, I mean, what remains in the property? Can they use it for an educational institution or any other institution?
Now, my lord, the first of all, my lord,
it's as good as acquisition or as
Absolutely.
bad as acquisition.
I know,
depending on the perspective.
Your lordship will put that question to me. I know that's why I
mean,
myself.
yes, you are right of user, but it's
First
a
of all,
nomenclature.
yes, my lord, first of all, my lord, I am asking myself, subject to my lord, that is this line passing the middle of the property?
Suppose it leaves 3/4 on one side, 1/4 on one
Lord,
side.
the line
Then also.
maximum, we are not, still not draw the line, but we are maximum portion. Right, about 90% portion of the line will be drawn over the water body.
Which is inside the campus.
Please, I'm not saying that outside the campus.
Inside campus, what about it has a meaning? If it's an education institution, they may swim there. If not,
Which is there. I cannot, on fact, I cannot make my submission anything wrong. Milord, on the, and Milord, in the very significant, what appears from their own writ petition, Milord. No, the acquisition.
So you say in the judgment cited, the interplay between the other fundamental rights and Article 30 was not taken note of. It was a question of Article 30 versus acquisition only. So for that, a new a specific act has to be enunciated and all this.
No,
but here you say it's not acquisition; it's a right of user for you, for which those judgments are not applicable. Here it's a question of Article 30 versus the general rights of getting electricity for all the others who will be catered to.
Yes. Why I am making my submission, Milord? Milord, just few weeks back, I have placed a judgment of that this is the Supreme Court says times without number. This is the national importance.
What? Electricity?
Yes.
Obviously.
And drawing the line. If that be so, Milord, the national importance.
Minority interest is no longer national interest.
I'm not saying that, but I just.
That is a majoritarian view.
Just why I've said that Article 30 confined to minority.
You're right, yes.
But others.
That was the intention of the constitution framers.
That is my point, Miller, here. But that is one of the main point. One of the main point. Miller, am I to Miller, say that I cannot draw the line because of minority? But no, not only that. Miller, I am placing something.
Mr. Pada, I'll put one other question to you. You are right. It's a very, borderline question. Now, suppose I accept your point that Article 30 cannot prevail over all the more basic rights, if I may say so. Right to life, sort of, and the other rights, Article 14 also. These are very basic rights, also equally applicable to minorities as well as the others. Now, even if that be so, here, is it such an absolute clash of interest between the two fundamental rights? I mean to say, if it was mutually exclusive, Article 30 is mutually exclusive with the exercise of a particular right, then you may have a valid point. It's arguable, at least very well arguable, whether the other right should prevail, the general right should prevail over the Article 30, which is more basic right. But here there may not be an absolute clash of interest between two rights. Article 21, Article 14 may very well operate, and Article 19 may very well operate without infringing into Article 30. Just if you deviate, that will be a peculiar proportion. Only the minority institution properties will have to be deviated from. But if it can be done, there's no absolute clash between the fundamental rights here. It depends on your modus operandi, the route you choose. So it is avoidable. It can be harmoniously construed.
Milord, yes, ma'am. Milord, when there was my friend already answered this indirectly way, that when there was a paper notification.
Inter mosa.
All time we say inter mosa.
Yes, maybe your plan was inchoate then.
Yes.
Not formed as it. Obviously, yes. But so the same moja choose some other land which is not where no minority institution is running an education society.
Milord, if I accept his argument, Milord, he himself said, I'm going to place that I need supply of electricity from high tension line. He himself said.
Who needs? Them.
Yes. No. Milord, may I say, my land friend probably not agree with it. May I say?
Even if he needs an electricity connection from a high tension line, does that justify violation of Article 30? That is a broader question here.
My point
Even if he needs.
My point is this, that if Article 30, they are covered, but Millard, they cannot ignore the other fundamental rights, because when Article
Yes, that
30
is that you have.
that is my main argument would be, one of the main argument, that Millard, and Millard, the Supreme Court has said, your Lordship knows I need not cite any reason, that Article 30 or all fundamental rights are not absolute. That is the point. Otherwise, Millard, country cannot survive. If now, Millard, I am drawing the high tension line.
Article 21 is also not absolute, Mr. Paja.
Absolutely.
If that was absolute, we could not have hanged any people to death.
Yes.
If you do that, the moment you do that, we execute a person. Article 21 is also not absolute.
Yes.
Nothing is absolute.
Yes. But Millard, when
Article 21 is, I mean, Article 19 is obviously not absolute. There are many propositions which go against Article 19.
Now, Millard, if today my company chooses to draw the line, they will have to find out which portion of the land belongs to
minority institutions.
minority institution.
Yes.
I cannot draw.
And if there are other statutes or other constitutional rights, you also have to find that out.
Yes. Now, Millard, then I cannot draw the line.
Literally or figuratively?
Whatever maybe.
Literally also you cannot draw the line. Figuratively also you cannot draw the line.
If
where
these
you have
types of
to
questions comes, Millard,
definitely.
that is a dangerous proposition. There are few hundreds of the buildings, the plots of land belongs to the minority institution. And minority people are asking for the electricity, for their own land.
So that does not justify violating Article.
No, I'm saying
it's a minority institution.
No, I'm saying
my right is irrespective of whether I'm a minority or a majority.
I put a question to myself: is this minority institution has started?
They are running a college from 2011.
I'm placing that. I'm placing that. Yes.
The risk in these provisions, Mr. Paja, is today, suppose this particular person may be already running a college, but there may be cases where a particular institution says, I'll make a minority institution, I have the papers. The moment the electricity connection is diverted, it is sold to a promoter. I mean, these also may happen. These are borderline cases which may take place. People may take advantage of this. So when we consider the law, we have to be very cautious on that.
But Millard, the problem,
not maybe in this case,
yes.
Obviously.
The problem is this, Millard. That is why the authority times without number, whenever they think that this project will have to be completed or completed, they invite the objection. They invite the objection.
Right.
Millard, they did not file any objection. And Millard, at the fag end of the project, if they say, no, don't do it. And Millard, not a matter of joke. This is, Millard, not a distribution line. This is a transmission line. Lordship has enough, Millard, the scope when I've argued this matter. I did not waste your Lordship's time. A transmission line cannot run zigzag method. It takes a huge area to Millard, divert.
You say 17 of the transmission posts have been already installed out of 20.
And I'm told that the location has already been fixed, and not a single tower is going to be fixed on their line.
Very.
And one thing, Millard, this is the first time I will make my submission on this subject. Lordship, kindly consider this aspect of the matter. Everybody is approaching this court. They have not placed that. That's why your Lordship has not no occasion to touch it. In future, I will do it. In future, I will do it. Millard, in saying this, Millard, then Millard, I cannot do anything. On the contrary, Millard, every day the people are asking us to supply the city, from where I will bring the that energy. Now, my lord, one or two things, my lord, page 68 of that. Read petition mark, page 668.
68, yes.
Of the writ petition. My lord, I will not take much time.
No, 68, yes.
My lord, Lordship, kindly see, this is the order of Government of West Bengal.
Yes.
Lordship, kindly see the date on the right of the top, 8 February 2023. Lordship, kindly see the second paragraph. I will not read it. And whereas, as per department's policy and guidelines for setting up a private university, the feasibility of the proposal needs to be verified upon causing physical inspection of the location of the proposed university, including its land, physical and academic structure. That's why we say now, next paragraph. Therefore, for this purpose, the competent authority of the state government hereby constitutes an inquiry committee consisting of the following persons, namely, so we lord, committee has been there. Now, next, my lord, page 70. Is number of, yes, page 70. Government of West Bengal. Regarding visit of the inquiry committee to examine the feasibility to set up proposed Dr. Bharati's Rao St. Mary's at.
Why are you placing this, Mr. Paja? Why are you placing this to show what?
The committee setup.
Committee setup, yes. So
68 page.
What is your point?
My point is that only on 19th April 23.
This committee is for starting a university there. They are already running a college. That is also an institution.
Willard, problem with me is this: one breath they are saying university, another breath they are.
No, they're not saying that. They're running a college there 11 years. Now they want to make it an autonomous university. They're asking for affiliation. Yes. For that purpose, these requirements are there.
Yes, I'm saying that
is neither here nor.
I'm saying why I'm saying, Willard, what I have understood from this read petition might not be very useful, but whatever is there. Lordship, kindly come to page 74. I am not reading entirely, just one or two portions to complete.
74, yes.
Lordship, kindly see the last paragraph. Whereas the proposed high voltage electric cable passing through and over our campus will restrict, abridge, and abrogate the right guaranteed under Article 31 of the Constitution of India. Now they are saying that we will hamper the additional construction. Where the date is 7th March 2023. Only on the other day after inquiry committee was set up.
Yes, Mr. Paja, let me hear the reply now. Yes.
One or two, three.
Yes. What else?
Things. Lordship, kindly see me page 82. It is our letter to them. Lordship, kindly read the second paragraph. It is worthwhile to mention here that the major quantity of the project has already been completed. And portion of the overhead conductor measuring about 136 meters. Lordship knows that 136 meters below.
It reiterates what you said. No tower will be placed. The connection line will go, and you also say that most of it will go over an water body in there.
and below they have a huge height. That is
That
the
has
reason.
to be maintained. Safety precautions has to be maintained.
They say that construction will come in future. What will be the height we don't know. But below we are aware that is why I have said that from ground level will be around 14.2 meters. It is there on the in this letter. Further, around 93 meter of the conductor hour of 136 meter will pass over water bodies. Just now I said it's very small portion, I say. Detailed scheme, schematic, drawings and plotting over Google Earth are being attached for your kind perusal. So, Millard,
yes,
nothing there is a height of this. That could have. So, Millard, my responsible submission is this, Millard. I don't think that there are any need to cite any decision, excepting one. Joseph to জানেন এগুলো একটা দুটো আমি দিয়ে দিচ্ছি কোথায় Millard, 2017 volume 5 sir লিখুন 2017 volume 5 SCC 143
Volume 5.
হ্যাঁ দাদা
Page number
143. Lordship need not take the trouble to read here also the same thing that out of 410 towers which are to be erected, 408 towers have already been erected. I will not read up to this, only this I will read. I have already placed this Miller once or twice before this court. So Miller, my lordship, kindly read the 3. Sorry. Yes. Peruse paragraph 3.
Paragraph 3, yes.
What is the power grid, which is a government of India undertaking, is primarily engaged in the work of providing framework for the distribution and transmission, just like our company, of electricity generated by various generating companies throughout country. In a way, it is discharging function which is in public interest. It is well known that India is an energy deficient country. Notwithstanding rapid expansion in this direction in the last few years, and particularly after the entry of private sector, insofar as production of electricity is concerned, still there are many households where lighting of even electrical bulb is a dream. Moreover, the socio-economic development of the country depends on this electrical critical infrastructure. Keeping in view these parameters, one of the objects of the power grid is to transmit of energy to remote areas. In the background of all these things, Miller, Supreme Court, what Supreme Court has held, Miller, I am reading. Miller, just I will read one line, I have placed it. Your lordship need not take the trouble to read or peruse. Just may I read paragraph 7. 85% of the work has already been completed with an investment of rupees 170 crores out of 400 towers. To erected, 390 towers have already been erected. Same case here. Same case here. Lordship, kindly take the trouble to come to paragraph 13, last 4 lines. I am trying to complete my argument as quick as possible. I know you're also hard pressed.
Thanks. Yes.
The sentence start, it could.
Yes.
It could. It could also not be disputed that the transmission project is of national importance, as it is going to benefit public at large, not only in the state of Chhattisgarh, as it is going to benefit public at large, not only Chhattisgarh, but various other states throughout which the aforesaid transmission line passes through. Project was at the verge of completion when the writ petition was decided by the learned single judge, and the same thing here. Just only 2 million or 3 million the tower had to be erected. More than 90% work have been completed. You see, it is a national importance, Millard. I have already placed it. That is why, Millard, at the outset, I placed Article 30 comparison with other. Why I said I have not compared this fundamental rights. But, Millard, Article 30 is not, Millard, this. You know, paragraph 21, I will not place it because time is short. Just last 10, 12 lines of this paragraph. Here, Millard, the Supreme Court has dealt with the Telegraph Act. Here also has enough, Millard, I have argued the Telegraph Act. The paragraph 25, again, I will not place it, only two lines, that the impugned action of the power grid was not contrary to the provision of the Electricity Act. This is my submission here also. Now, Millard, just now so long I was making my submission, paragraph 26, Millard. I said that this is not distribution line, this is a transmission line. I cannot draw according to my wish, Millard. This is, Lord, you can see 1, 2, 3, 4, 5, 6, 7, 8 line from the top, paragraph 26. Sentence start. Such transmission lines. Have you also got it, Millard? Yes. Such transmission lines had to be in straight line to the extent possible for eliminating loss of transmission. It is also explained that electricity transmission is usually laid or crossed over the agricultural land. Here also, where minimum extent of land gets unutilized for erecting towers and where agricultural activities are not prejudiced, obstructed in any manner. The purpose is to avoid buildings, religious places. Here, Millard, why we have diverted? Because when we are drawing the line, we find that there is a, Millard, the residential building and all these things. Now, Millard, our High Court has also, Millard, considered Article, Millard, the electricity under Article 21. May I cite or no? You can cite to cite because it is known to us, Millard.
Now, Article 21, as I said, regarding Section 40 is the right to get electricity.
Yes, yes. That's why it is said that electricity is within broad sweep of the right to life guaranteed under Article 21.
Since you are citing, cite it.
2000 AIR 2009 Calcutta. Calcutta, page 87, division bench.
Particular para?
I'm showing the 2009 Calcutta 87. In 2008 Calcutta. Page 47.
Yes.
Then, my lord, next submission would be my lord, this citation. 2008 Calcutta. Okay. Page 47. On the same point, my lord, paragraph 25.
Right. Yes, let us not multiply on this.
I'm not multiplying. Just
point is settled, but I'll take these two judgments.
yes. Now, my lord, another thing, my lord, that on different points, my lord. You know, I so long I was saying that Article 30 or other things are not absolute. This I find from the judgment of the Supreme Court.
Yes.
May I cite that?
Yes, if you're citing cite.
2003, volume 6 SCC, page 697.
Right.
This is the famous judgment of Supreme Court, Islamic Academic Education Society. This is 5 judges bench, my lord.
এইগুলো আপনি দিয়ে দিন।
Paragraph 25, my lord. This has, my lord, confined to the interpretation of TM pi. That is a famous. Now, my lord, Lordship, kindly take the trouble to paragraph 101 to 103.
Yes.
And paragraph 39. Paragraph 39 also. Right under clause 1 of Article 30 is not absolute. Only for that.
Para 39.
101 to 103.
Yes.
Then Miller paragraph 39 in fact.
Very yes.
And only one paragraph from this Miller, paragraph 46.
Para 39, 46, 101 to 103.
Because this is not absolute.
Right.
So, Miller, my submission is this, Miller, that if I am not allowed to draw the line over the plot of land of the minority, then, Miller, there will be no, sorry to say, Miller, there will be no project. It's very difficult to find out which plot belongs to them, this plot belongs to them.
Good.
And Miller, I have said that already the university said that I need high tension line, the energy from this. The specific paragraph is there. No. So, Miller, they need. And in future, when the construction will come, what types of construction would be there, what will be the height? We are not
Yes, for this.
My lord, as far as the Article 30 concern, absolutely, I want to cite TMA Pai judgment, Supreme Court.
Don't
It's
cite new judgments in reply.
uh,
You have had your opportunity of citing.
okay. My lord, TMA Pai judgment says she has quoted it's 11 judge bench of Supreme Court.
You are referring to that, you are answering to that Islamic Academic Association.
Yes,
Very well, then you cite.
yes. That this. My lord, paragraph.
Give the citation for your learned friend.
Yes, this 2003, just a minute, my lord, 2002 SCC 5481.
2002, volume 8 SCC.
Yes, page, start from page 481. My lord, I am citing two paragraph only, paragraph 270 and paragraph 271.
Right.
Just a minute, my lord. In 270, the Supreme Court has reiterated the judgment of six bench judge of Supreme Court, a 6-judge bench of Supreme Court delivered in Reverend Sidabji Bhai Sahai and others versus State of Bombay, which I have already cited. That right established by Article 30 is a fundamental right declared in the terms absolute. And in page para 271, they said to make the right under Article 30 real and effective, the regulatory measures have to be consistent with the right. My lord, one more, they said that cited few judgments of Supreme Court and this court also. None of these judgments dealt with minority educational institution. Regarding zigzag of diversion, they said that it is not permissible because voltage will down or something. But they have already diverted, my lord. Once they have diverted, what is the wrong in divert twice? And my lord, they said that continuity. My land is measuring 7.21 acre. Is this land is bifurcated from my land? I will not be eligible for university. And they have cited that my letter. They have never given us any intimation that over your plot we are drawing line. It is us, page number 73 of my writ. I have strongly objected twice, thrice through letter. Whereas from local people we came to know, however, no official notice received by us.
Official notice cannot be given to each and every landowner.
No.
There are umpteen landowners in.
No.
These are transmission lines.
Yes.
It runs over kilometers and thousands of kilometers.
Yes, my lord.
Each and every individual cannot be given a
No.
notice. The public notice is always given under the statute also.
Public notice without mentioning plot number. How should I know when they have drawn the line? Then my plot was not considered. Afterward, they have diverted whatsoever the reason may be. And my lord,
yes,
if this done, then my right is infringed. And Supreme Court categorically said that right of minorities is absolute. And university will not be established, and the running present institution, which is the engineering college, will also not be continued. So it will be a great loss to the society also, not only us, to the society also. And my learned seniors are said that there are hundreds and thousands of lands. My lord, in India, there are hardly 1 lakh of minority institution, maybe. So my humble submission before the court, my lord, kindly consider our case and direct them to divert. Otherwise, let them compensate us accordingly as per Supreme Court, give them same land, same compensation, we will leave the campus.
Hearing is concluded, judgment is reserved in the matter. বইগুলো ফেরত দিন।
Obliged, my lord.
Thank you. Good argument by both sides.
My signature. This is mine.
ওইটা আপনার দেখুন।
এইটা ওইটা
এটা চলে যাবে।
Any original side mentioning?
Sound. Thank you. Yes.
Original side matter, court application under Article 226, item number 1 and 2.
My lord, in item number 1 and 2, Mr. Om Narayan Rai is appearing for the respondent bank, my lord. He has left the court because of some personal difficulty, but I'm only praying for days accommodation.
On the prayer of the respondent, on the prayer of the respondent bank, the matter is adjourned for the day. Yes. Please give the appearance, Mr. Both
Yes,
of
yes,
you.
ma'am.
So manager, please ask your junior.
Yes, yes. Appearance.
Item number 3.
Your lordship, I appear for
Yes.
the petition of. Affidavit for Mr. Law. Affidavit of service.
Service.
Service. Service. Lordship.
Good service on all.
Lordship, the respondent number 1, that is the UCO Bank, they have refused.
Refusal is good service.
Lordship.
Stand up, please. It's fine. Yes, what is that?
And the others shows it's delivered.
Who has received?
Lordship.
The UCO Bank has received, the customer sale has not. Anyway,
Lordship.
very good. What is the matter?
Lordship, the grievance is that, your lordship, there was a loan which was taken by the petitioner. Lordship, the loan was taken by the respondent number 3. Only the respondent number 3 had taken a loan, and this in the loan agreement, he was the only signatory, your lordship. The loan agreement is at page 40.
Right.
It's 27th of July 2022. A loan was taken. And lordship, at page 65, it shall appear Devanando Tung is the borrower. Page 65. Lordship. Now, thereafter, there was a failure in payment of the loan. It was a personal loan of an amount of rupees 10 lakhs that he could not pay. He has only paid an amount of 77,000 and odd. And thereafter, a notice was issued. And thereafter, your lordship, a section 9 application was preferred. And pursuant thereto, the first order which was passed is at page 68, annexure P3.
Right.
Lordship, may I place the order?
Please.
There's an order dated 28th of February 2023.
This is a section 9 application. Upon hearing counsels on behalf of the petitioner, I direct the respondent to show cause as to why he should not be directed to immediately furnish security to the tune of rupees 10,84,525 before this court. This order be served upon the respondent immediately and affidavit of service be filed on the returnable date.
This was the due according to you at that point of time.
Lordship. That was duly communicated to the respondent number 3. Lordship, thereafter, the next page, Your Lordship. The next order was passed on 28th of March 2023, whereby on 20th February 2023, this court has issued an order show causing the respondent as to why they should not be directed to furnish security to the tune of rupees 10,84,525 before this court. In spite of service of the order, none has appeared on behalf of the respondent, nor has the show cause been addressed. In light of the same, let there be orders in terms of prayer B of the notice of motion, and accordingly, the bank account details as appearing in the petition and as provided by the petitioner in court today are provided below. So the first account belongs to UCO Bank and the next is of Axis Bank. Now, the above two accounts are to be attached by the bank concerned immediately, and the banks are directed to file a report before the court on the returnable date. Lordship, there were two bank accounts, one of the Axis and UCO. We have no grievance against Axis because they have already acted upon. Lordship, despite there was a direction for filing of report, unfortunately, Your Lordship, there has been no cooperation on behalf of UCO Bank throughout. Lordship, the very next page, page 71. Lordship, no report has been filed before the Honorable Court.
Report, there was a direction of it?
Lordship, there was a direction. And to file a report before this court on the returnable date.
Right.
In the section 9 application, they had never filed a report. Lordship, the next page, Your Lordship, page 71, it is immediately by a mail of 1st April 2023, this order was communicated. Lordship, pursuant to the communication at page 72, Lordship, may kindly takes page 72.
Yes.
Lordship, this is a communication from the UCO Bank. As regard in the court order, we have freezed the account number such and such belonging to Devananda Tung. It is for your reference and necessary action. So pursuant to the order of 28th March 2023, the account was freezed. Lordship, thereafter, the matter was once again heard. And that is the order is at page 92. Annexure P9.
Yes.
Lordship. Herein, the respondent number 3 has appeared. Learned counsel appearing for the petitioner as well as the respondent submit that the parties have settled the dispute out of court and places an undertaking declaration letter of 6th May 2023 given by the respondent
You said page
to the
92, I'm sorry.
page 92, Your Lordship.
92 is something else.
Lordship, this order is again repeated at page 96. This is an
My
order.
copy, the first one is 94. Very well. I'll take up
This
90.
is an order passed by Honorable Justice Moushumi
Justice
Bhattacharya.
Moushami Bhattacharya, 94 and 96 in my.
Your Lordship, the
Very well, I'll
only
take up
one order.
94. Yes.
Lordship, only one order,
So let's-
27 June 2023.
True. Please continue. Yes.
The undertaking declaration letter of 6th May 2023 given by the respondent to the petitioner. The undertaking mentions two bank accounts of UCO Bank and Axis Bank together with the respective account numbers. The respondent has undertaken to settle the loan agreement for a total settlement amount of rupees 10 lakh in one transaction. Lordship, this is arising out of the undertaking, which is part of the annexure here. Counsel further submits that by an order passed by a learned single judge on 28th of March 2023, two bank accounts mentioned in the said order of UCO Bank and Axis Bank were directed to be attached by the concerned bank. It is hence submitted that appropriate order should be passed so that the petitioner can realize the amount undertaken to be given by the respondent. After considering the declaration given by the respondent and the fact that the two bank accounts of the respondent remain frozen pursuant to the order dated 28th March 2023, AP 54 of 2023 is allowed and disposed of by directing the concerned banks, namely UCO Bank and Axis Bank, to defreeze the respondent's accounts mentioned in the order dated 28 March 2023. The party shall be at liberty of taking appropriate steps before the bank in this regard. Lordship, this order was passed on the understanding that the dispute which is to be settled on the basis of the declaration given by the respondent number 3 that the money can be realized now from these two accounts. Once this is complied with, thereafter the defreeze takes place. Lordship, page 97, the second paragraph, page 97. Once this second paragraph of the order is complied with, thereafter comes the third paragraph.
Undertaking is filed. Let us revisit that.
Lordship, the undertaking.
Respondent has undertaken, the undertaking mentions two bank accounts. Respondent undertakes to settle the loan agreement for a total amount of rupees 10 lakh.
10 lakh something.
In one transaction.
One transaction.
What is the undertaking annexed?
Lordship, page 78.
The undertaking says, I undertake to state that this is about the fifth paragraph from the top.
Lordship.
I undertake to state that I am ready to settle my loan agreement such and such with total settlement amount of rupees 10 lakh in one transaction and requesting you to adjust the frozen amount from respective bank towards outstanding amount upon payment, residual amount as per. Apparently, you would take the amount and the residual amount would be disbursed to him.
Lordship.
As per this undertaking at least.
Undertaking. The Lordship,
So this, if this is read in conjunction with the order, then your contention.
Lordship, this everything took place in the presence of the respondent number 3 and it is on the basis of an undertaking, your Lordship.
Was recorded in the court by the court.
Right then.
Of course, the undertaking to record it.
It was placed. It was present with no objection.
Lordship, thereafter, this order was once again communicated to the UCO Bank. That is at page 111, annexure P12.
Ultimately, what happened? I cannot hold this suspense.
Lordship, ultimately what happens?
Yes.
Now this account details were given by the respondent number 3, disclosing that this is initially his salary account. He is by profession a doctor. Now when this is entire game is being played by UCO Bank, your Lordship. Your Lordship may kindly see that UCO Bank has refused the service also. Now UCO Bank has defreezed the account, but had kept the amount on hold, communicating us that this account belongs to the husband and the wife jointly. So since the wife has come before UCO Bank and has expressed her willingness not to give a signature for disbursement of the amount, so UCO Bank cannot disburse such amount. This was the communication by UCO Bank as on date.
Account is in joint name.
It is in joint name.
You should have been careful when you took the undertaking. I mean, you furnished the bank account.
Lordship, it was
The
furnished
disclose-
by the respondent number 3. He gives a declaration. He
No,
gives
Justice
two
Sharaf at
accounts.
the first instance pass that order of attachment. Please come to
Lordship.
page 71.
Lordship.
Page 70, they were not present at that point of time.
Lordship. Lordship, but when the order
In
was
terms of B, prayer B,
prayer B.
you gave the account numbers.
Yes, Lordship, these details were earlier given at the time when the arbitration was taking place. Your Lordship, this accounts details, I could not have got it until and unless those accounts were given by the respondent number 3 himself. Lordship, even assuming, your Lordship, this account details were furnished by me. The moment the respondent number 3 had entered appearance, he could have clarified that this account belongs to me along with my wife. He has throughout made a
He
statement.
has obviously duped you. Any
Lordship.
idea how much amount is lying in those accounts?
Lordship, it's 8 lakhs.
8 lakh.
8 lakhs. Lordship, out
So
of
how
the
much has been
total-
adjusted out of the other account?
Lordship, may kindly cease.
adjusted হয়ে গেছে
From Axis.
You are
From
entitled to
Axis.
10 as per the
Lordship, my entitlement is 10. Out of that, Axis Bank has given me 2 lakhs. And the remaining 8 lakhs is to be recovered from the amount kept with the UCO Bank.
What is the total amount lying in that account? Any idea?
Lordship, as on 21st of April 2023, it is 8 lakh 339.
So the entire amount virtually has.
Entire amount. And this amount is not that it amount has come 8 lakh exact figure. Lordship, this is from his gratuity, which he has got to this account so that it can be disbursed in favor of the petitioner. But it is the UCO Bank which is keeping the amount on hold. Lordship, I'll make only.
But can we bind the lady, the wife? She was never a party anywhere.
Lordship,
She was
now-
not a borrower, guarantor, nothing.
21
Lordship, may kindly take speech.
ফর্মে সাইন করে
Mr. Munshi has
What-
found something to embroil her.
Lordship, he was appearing earlier.
He's all alone, actually.
Page 121, Your Lordship.
পেজ
Her wife has also given a consent, and today we have also served both of them.
So that is there.
Lordship,
That
Lordship. Page
Even-
121.
121, right?
thereafter the bank
Hey, Tara. Lordship, may kindly seize the RTGS. The signature at the top is of the respondent number 3, and Chinmoy Tung is the respondent number 4, the wife. Page 121, Your Lordship.
on the left side.
This is the communication dated 28th of June, 2023 at page 121.
Lordship.
Pagination is that you're relying on that.
Lordship, this is the relevant portion wherein both the signature of both the husband wife is there.
along with the declaration and the declaration দিয়েছে যে আমি টাকাটা ডিসবার্স করব along with this RTGS was furnished and now the
দেখাচ্ছি তারা একটু দেখে নি কোশ্চেনটা করছে সেটা আগে উত্তর দিই আগে কোশ্চেনটা করছে
Page 121, I don't find any signature of any.
Lordship, page 120 and page 121, annexure P13, the volume 1.
Handwritten.
yes
Lordship, page 120 is handwritten, but page 121 is the UCO Bank slip, Your Lordship. Lordship, this is
All
what
right, the
is-
pages are not telling actually.
Lordship,
There will be yes.
may I hand over my document?
He's
to Lordship?
Chinmoy something.
Yes.
yes
Yes, yes.
একবার দিই।
Right. Yeah, please.
And Lordship,
Hmm.
page 121 and page 120 is the handwritten declaration which refers to the RTGS made at the next page of page 121. Wherein the respondent number 3 states, kindly release the fund of rupees 8 lakh as per the order of the High Court at Calcutta. It is his own declaration, and the RTGS is not signed only by the respondent number 3. The very next page, it is signed by both of them. It is, the order has been passed on consent.
You want a direction on the UCO Bank to release the entire amount to you.
Lordship,
That is a
in favor of the petitioner. Lordship, I'll once again, I'll just see the affidavit of service type for that one.
original
Original to দিয়ে দিয়েছি। দাঁড়াও, item delivered, সবার তো delivered হয়েছে তো, রঞ্জিত?
কিন্তু ডেলিভার হয়েছে একটা রিফিউজ করছে
Respondent 3, 4 to delivered হয়েছে তো? হ্যাঁ, ঠিক আছে। Lordship, respondent number 3 and 4 has, it shows delivered.
I'll pass my order. Yes. Act order. Learned counsel, despite service, none appears for the respondents. Affidavit of service and the envelope filed in court today be kept on record. Stop. Next para. The respondent number 3 was a borrower from the petitioner stroke finance company. Full stop. Next para. the respondent number 3 having failed to repay the loan, comma, proceedings were initiated. Full stop. Ultimately, an application under Section 9 of the Arbitration and Conciliation Act 1996 came up for consideration before a coordinate bench of this court, comma, being numbered AP stroke 54 stroke 2023. Full stop. With a order dated February 28, 2023, comma, the learned single judge directed the respondent to show cause as to why he should not be directed to immediately furnish security to the tune of rupees 10, 84, 525 before the court. Full stop. Next para. Since none appeared on the next date when the matter was called on for hearing for the respondent stroke borrower, comma, with a order dated March 28, 2023, it was directed that 2 bank accounts of the respondent were to be attached by the bank concerned immediately, and the banks were to file a report before the court on the next returnable date. Full stop. One of the said accounts was lying with the UCO Bank and the other with the Axis Bank. Full stop. Insofar as the Axis Bank is concerned, comma, it is contended by the petitioner that the said bank complied with the direction of the court. Full stop. Next para. However, comma, the UCO Bank initially did not respond to the communication made to it. Full stop. Next para. Subsequently, however, comma, an email was sent by the UCO Bank indicating that the order of the court had been complied with and the said bank had freezed the account in question bearing account number 043801 number 043801 4 zeros 6993 belonging to the respondent number 3. Full stop. Next para. Ultimately, the matter culminated in a settlement between the petitioner and the borrower stroke respondent number 3. Full stop. The respondent number 3 filed an undertaking, comma, whereby the said respondent expressed the intention to settle the loan agreement with a total settlement amount of rupees 10 lakh in one transaction, comma, requesting the petitioner company to adjust the frozen amount within bracket from respective banks, bracket closed, toward outstanding amount upon payment of residual amount as per undertaking. Full stop. Next para. Taking note of the said undertaking, comma, with a order dated
27 June.
Right. June 27, 2023, passed in AP stroke 54 stroke 2023, comma, a coordinate bench observed that the respondent had undertaken to settle the loan agreement for a total settlement amount of rupees 10 lakh in one transaction. Full stop. Considering the same and the submission of counsel, comma, the court went on to record that AP 54 of 2023 was allowed and disposed of by directing the concerned banks, comma, namely the UCO Bank and the Axis Bank, comma, to freeze the respondent apostrophes accounts mentioned in the order dated March 28, 2023. Full stop. Next para. The petitioner argues that although the Axis Bank complied, comma, the UCO Bank has not complied with the said direction to the letter, comma, since although the accounts were defrozen, comma, the dues of the petitioner were never disbursed in favor of the petitioner. Full stop. Learned counsel for the petitioner places reliance on annexures to the writ petition to indicate that there was a request made by the borrower stroke respondent number 3 in favor of the UCO Bank, comma, asking for disbursal of the amount and defreezing the account in terms of the order of the coordinate bench. Full stop. In fact, comma, the respondent number 4, comma, the wife of the borrower stroke respondent number 3, comma, had signed on a NEFT stroke RTGS funds remittance application form filed before the UCO Bank for such purpose. For sub next para. However, comma, thereafter, the amount is not being disbursed by the UCO Bank in favor of the petitioner on the pretext that the account stands jointly in the name of the borrower stroke respondent number 3 and his wife, comma, the respondent number 4, comma, the latter not being a party to the entire transaction. Full stop next para. Since the respondents choose not to appear despite service, comma, the matter is taken up for disposal ex parte. Full stop. A bare perusal of the undertaking given by the borrower stroke respondent number 3 shows that the clear understanding was that the parties had agreed to a settlement amount of rupees 10 lakh in one transaction. Full stop. The petitioner was to adjust the frozen amount from the respective banks towards the outstanding amount upon payment of residual amount as per undertaking. Full stop. The expression within double inverted residual clearly shows that the the settlement amount was to be disbursed in favor of the petitioner, and thereafter the residual amount was to be disbursed to the borrower. Full stop next para. Since the respondent number 4, comma, the wife of the borrower was also a party to the understanding, comma, to the extent that she had signed the remittance form for defreezing and reopening the amount with the UCO Bank, comma, it cannot be said that the respondent number 4 was not in the know, KNOW, know of the entire transaction and the settlement. Full stop next para. Moreover, comma, there is nothing on record to indicate that there was a strained relationship between the petitioner, between the respondent number 3 and the respondent number 4, comma, spouses of each other. Full stop. Thus, comma, it can very well be construed that the respondent number 4 had full knowledge of the entire settlement and had taken advantage of the same by being instrumental in defreezing the account with the UCO Bank. Full stop. Since the undertaking given by the borrower has acquired the complexion of an order of the court, comma, it is the bounden duty of the UCO Bank to honor the same. Full stop. Accordingly, WPO 1540 of 2023 is allowed, comma, thereby directing the respondent numbers 1 and 2 to ensure that the amount of rupees 8 lakh, comma, the remaining amount of the mutually settled sum, comma, be disbursed in favor of the petitioner from the account of the respondent number 3 and 4 jointly with the UCO Bank, comma, being account number 043801, তারপর 4 zeros 6993 as expeditiously as possible, comma, positively within a fortnight from the date of communication of this order to the said respondents. Full stop. The parties shall act on a server copy of this order without insisting upon prior production of certified copy for the purpose of compliance. No address to cause certain.
Grateful to your lordship.
Thank you.
Grateful.
For hearing, item number 4.
Yes.
My lord, firstly,
Yes.
I would like to answer. The state respondent, my lord, against whom basically the writ petition is directed.
Right.
No affidavit in opposition has been used by the competent authority. Now, my lord, a question was put by your lordship under section 10A to whom the notice is required to be given. That was first and pertinent question, my lord. My lord, in fact, section 10A makes it mandatory to give the notice and to hold an inquiry. I would show, my lord, because I didn't have a copy of the form here. In the affidavit in opposition at page 179, my lord, my learned friend, private respondent has annexed the copy of the form A.
Please give me the page number once again, Ms. Agarwal.
179, my lord. Sorry.
Yes.
Annexure R7. My lord, your lordship would take note of the fact that the order which is under challenge is dated 18th May 2022. And kindly see in R7, the first stamp of the competent authority accepted 18th May 2022, the very date on which the application is filed. So, my lord, no inquiry as required under the act was made, no notice was given. And my lord, to whom the notice would be issued, my lord, under the section 10A of the purpose. On section 10A, subsection 2, my lord, on receipt of a declaration or an amendment thereto, or an instrument referred to in subsection 1, the competent authority shall, after issuing notice to the parties concerned, and after holding such inquiry, if any, as it may consider necessary for the purpose, examine the declaration, the amendment of the instrument, or the instrument, as the case may be, to ascertain whether the property concerned comes within the purview of this act, and the declaration, the amendment, or the instrument is in order. But your lordship will find from the very application which is annexed by the private respondent at page 179, the moment the application is submitted, my lord, it has been accepted. So, my lord, there has been no compliance, whether it is applicable or not, my lord. That is a secondary issue, my lord. The first is the competent authority has not acted in terms of section 10A.
Very good. Yes.
My lord, this is the first point, my lord. Secondly, my learned friend has in the affidavit in opposition stated that he is the authorized representative or power of attorney holder of 144 flat owners, my lord. Kindly see, my lord, in the affidavit in opposition, he has annexed a power of attorney of only 30 flat owners, which is at page 342. And before that, my lord, you will find there's one document which contains the signature of 16 flat owners. General power of attorney is as page 342. And page 324, 16 flat owners. of
not
the affidavit
majority.
in opposition. These are the two things, my lord, 144. Thirdly, my lord, your lordship will find. I shall show to your lordship what the law was. This West Bengal Apartment Ownership Act, my lord, what it is stood in the year 1992, my lord. Just a second. My lord, there was a clause L in that act, my lord, your lordship.
Why is that relevant?
I'll give you, lordship.
Yes.
Just इसमें निकालोगे page 8. In this book, it is page 894. My lord, I just got hold of it.
This is which section?
I'll give you a lordship section. Page 89, it's section 3A.
Of the Apartment Ownership Act?
Yes, West Bengal. My lord, this is not there in the present act. It has been deleted. Section, there was section 3A.
Yes.
3A, my lord, it says member of a cooperative society where such society is the owner of a property to be the owner of the apartment of such property in his possession for a limited purpose. My lord, now this has been deleted, my lord. My lord, the legislation has done it knowing fully well that it cannot cover cooperative society. My lord, just.
No, need not give the book. I mean, give a photocopy when I'll request you to file short written notes of our.
Very well, my lord. I shall do it, my lord. This is one thing, my lord.
So previously, cooperative societies were there.
Cooperative society was there, which was introduced by way of 1992 amendment, and it was there. And it was in the present act, your lordship will not
So
find
the intention of the legislation was to
remove cooperative society within the ambit of this act, my lord.
But you are you are insisting upon cooperative society to be formed.
No, my lord. They are insisting for the Apartment Ownership Act 1972.
Right.
Similar to they say that irrespective of the fact whether a cooperative society is there or not, we are bound by the Apartment Ownership Act 1972. This is their contention which I am meeting. So, my lord, it has been omitted. Therefore, my lord, cooperative society, my lord, cannot be brought within the purview of Apartment Ownership Act 1972. Now, my subsequent next argument is, my lord, it has been argued, my learned friend has cited section 87 of the West Bengal Cooperative Society Act to show the eligibility criteria. And, my lord, rule 132 in the rules 2011. My lord, this, when the brochure was circulated, and my lord, along with the form to be filled up to become a member, to apply for allotment, my lord, these standard terms and conditions were circulated. It was well within the knowledge of each of the person, my lord, who was acquiring the property therein, that these are the standard terms and conditions that a cooperative society would be formed. My lord, now, my lord, why they want to become a member of the Apartment Ownership Act 1972 is to come out of the rigors of that eligibility criteria, because there is an embargo in freely transferring the property, and they have to seek permission. My lord, that
there was a rectification in your documents which
it is that proper persons from all walks of life.
So you say that is circumscribed by the cooperative requirement?
Yes, it is circumscribed. I have never said that it will not be a cooperative. And then, my lord, the deed which they have executed, one deed, my lord, most around 58 flat owners have not executed the deed of conveyance, my lord, as it is still due and pending. My lord, the STC is not a registered document, my lord. However, my lord, the deed of conveyance which my learned friend has annexed, and he has placed before your lordship, my lord, yesterday, only I'm referring to some of the clauses. Clause, which is in their affidavit in opposition at page 60.
Yes.
Clause E, my lord, clearly speaks about the formation of a cooperative society. On formation of the cooperative society, the developer herein shall make over to the cooperative housing society the amounts of sinking fund or the balance amount thereof as may be then lying with the developer. Then, my lord, kindly see clause F. The cooperative society is to be formed as envisaged herein shall manage and administer the maintenance of the common parts and essential services at the building, including those mentioned in the third schedule hereunder written, and further to collect the monthly maintenance and service charges from the owners and or occupiers of different units at the building complex, as also to disburse, incur and pay all costs and charges. Then, my lord, it's very important is, then G is also relating to the same also, I'm not repeating, my lord. Then N, they spoke about the STC. That STC is not binding, it is an unregistered document. This is what has been argued by my lord. Clause N, kindly see. They have ratified it, my lord. 62.
Yes.
The purchaser herein shall duly observe and perform the various terms, conditions, covenants, and stipulations contained in the said standard terms and conditions dated 29th February 2012. So, my lord, they now cannot say and escape that STC was not binding upon them or is still not binding. It is binding upon them, and shall not do or permit to be done any act, matter, or thing which may in many manner cause violation and a breach of any of the terms, conditions, covenants. But these, then, my lord, kindly say, I've shown to your lordship. Those units में क्या है? उनका युगा. Second one. Then, my lord, page 219 kindly take of their affidavit in opposition. And all these are, Mr. Mohanty has signed on behalf of 144 flat owners. (219) is the list. Starts, my lord. And he has put the signature to make the number 144 from 2192 to 225. It's only one person. Power of attorney is only of 30 persons.
30%, why do you say?
30 persons power of
Power of
attorney, they have
attorney is
annexed.
30.
Power of attorney, 30%, 16 other persons themselves they have signed.
These
Now, my lord,
144,
and one more,
144 have been signed all by Mr. Mohanty.
all by Mr. Mohanty. And power of attorney is 30. And my lord, I shall show your lordship the circular. Why I was showing yesterday to your lordship. The circular, which clearly says, my lord, the power of attorney of all the flat owners is required to be annexed. Take copy of it. Circular. I've given a copy to your lordship yesterday, one circular.
Of what?
Of circular that has been issued by the competent authority.
Yes.
Under the West Bengal Apartment Ownership Act 1972.
Right. Got it.
I'm giving a copy to my learned friends also. My lord, this circular is required, my lord. Why, my lord? Kindly come to page 3, bottom. Documents and papers to be submitted with Form A.
Yes.
Yeah, page 4, kindly see declaration in Form A 2 sets executed in a non-judicial stamp paper of ₹10 solemnly affirmed before a magistrate or a notary along with the annexures from A to E. Annexure A, authenticated copies of building plan. Annexure B, copy of site plan. Annexure C, copy of relevant completion certificate.
The last sentence.
Annexure copies of receipt of letter in Form E served to all the apartment owners. Where this has not been done.
The next one also.
And if the declaration in form is made by a constitutory duly authorized by executing an instrument of power of attorney, then the original copy of the power of attorney to be enclosed along with the Form A. So, my lord, this has not been done, my lord.
Very well. So if you say that if this copy, these were not done, basically.
These were not done.
Very well.
And, my lord, I am the person, my lord, apart from being a promoter, my lord, I am the only person, my lord, who can provide all these documents, including building plan, site plan, and all verification has to be required to be done through me only, because I am holding all the details and data of the building concern. Apart from that, still, I am holding several flats in my possession. As an owner also, I am entitled to get the notice if my land friend says so. The notice in Form E is required also to be served upon me. And now the competent authority has not produced any document. Question does not arise, my lord, because very first day, the moment the application is submitted, it has been accepted and order has been made. These are my submissions.
My lord, looks like my learned friend has repeated the submission what she has already done yesterday. But what are the additions that I could make out is that my lord, the numbers of perhaps the power of attorneys are not there. And secondly, my lord, on the very same day when the application was submitted, it was allowed, as I could find out from a submission, my lord. But the reply is apparent from my affidavit in opposition itself, my lord. My lord, kindly appreciate the no public authority can approve. And
make it short, no reply to reply, make it short.
Yes,
These are the additional points. So
I will limit myself to the additional points only. My lord,
Yes.
kindly comes to page number 220, my lord, or 219. Kindly see the notarized, my lord, seal, 10th May 2022. I have taken the instruction in course of hearing also from my client to my junior, what happened actually. My lord, it is a, my lord, continued, my lord, effort.
Continuous process, yes.
Continuous process, right, my lord. So thereafter, my lord, we once submitted, thereafter few defects were, my lord, pointed out, then we cured, and it continued for a long time. So from my annexes, my lord, it apparent few of the documents is bearing the notarized seal of September 2019 as well. So, my lord, at the time of filing my affidavit in opposition, my lord, we have just collected all the documents available and we have made a part of it. And as for the power of attorney is concerned, that also I have taken instruction. All 145, my lord, flat owners given the power of attorney in favor of Mr. Mohanty, and on that basis, the application was submitted. My lord, all the 145, my lord, attaching all the 145 power of attorney, my lord, would not have, my lord, make this particular affidavit in opposition would convenient for all of us. So that is why. But in any case, my lord, if this question arises, I can always submit all the 145, my lord, the power of attorneys.
How soon can you file your written notes of arguments?
Yes, my lord.
Mr. Rai, you will also have to file a short written notes. Because you made certain salient points also.
And the clock cannot be set back anymore, my lord. Only in one line I can summarize. The clock cannot be set back. Even if the intention was there, that is not possible anymore. Because the persons
I
are
have not
eligible.
argued because it is a subject matter of a civil case. I have in my GA, I have an extra chart in my application also that more than 5 crores is due and payable by them. In
It's
order
more
to
on the
outline,
interplay,
that
more
is
on
why,
the interplay of the
yes,
statutes.
that is why, my lord, I
So
don't.
please file it short, very short written notes of arguments.
Yes.
Do it on Friday then.
My lord, make it on Monday, my lord, Monday.
Monday, then it has to go after 2 weeks. Because I'll not be there, I'll be in Jalpaiguri bench.
Very well, I shall file it by Friday. my lord.
Friday, just make it very short. Just,
Very short, small.
I've
just,
taken my notes, but just
Yes,
to
yes,
collate the things, give the
yes,
page
yes, my
numbers.
lord.
All the points taken by all the points.
Yes.
Very
Great.
short.
Please
Lovely,
continue.
my lord. Extremely grateful.
Oral arguments are concluded. Let the matter be listed on September 8, 2023 at the top of the list for filing of written notes of arguments by learned counsel for the parties.
Extremely grateful.
Deeply obliged.
Thank you. Yeah.
And my lord, this page, I'll just, the Act 1992, my lord, Amendment Act, I
You
shall
can
annex
just
it.
take out of, if it is possible, that's
No, it is possible, my lord. It is available on the net, my lord.
Very
I'll
well. Just give that page only to.
Yes.
Next.
Item number 5.
Yes.
Number respondent? I'm for respondent number 2 and 3, my lord.
Yes. You're playing hide and seek. Either the petitioner is not there or you are not there mostly. But sometimes the petitioner
For
is.
that I tender my apology, my lord. Mr. Mitra was here just now, but possibly some matter has been called on. He came here. Mr. Abhijit Mitra is for the petitioner. He came just now.
What is the matter about?
So this is not regarding incentive under the West Bengal incentive scheme to the petitioner concerned. It's a company. The grant of incentive has been denied on certain ground.
Time or argument?
My lord, Passover, my lord. My lord, short Passover, my lord, actually.
No, short Passover now at 4. Very well, then come back tomorrow.
Tomorrow.
An adjournment is after order record. Adjournment is sought by the petitioner. Let the matter stand over till tomorrow.
Grateful, my lord.
Item number 6.
Yes.
Manager,
Manager, please give the appearances in the. Yes, thank you. Yes, item number 6.
6, my lord.
I'm appearing for the petitioner, my lord, in this matter.
My lord, recalls it's that matter, my lord, wherein the certain order passed by the Calcutta Stock Exchange has been
Oh, that.
challenged.
Yes.
Sorry.
No. Yes.
My lord, I believe a list of dates has already been handed up to your lordships.
Yes.
My lord, this is a, my lord, fairly curious case. My lord, my clients, my lord, are, my lord, stockbrokers. My lord, about, I think, my lord, more than 18 years ago, my lord, there were, my lord, a few, my lord, sharks, my lord, in, my lord, the stock exchange. My lord, the first one, my lord, which became public was Harshad Mehta. Then, my lord, there was Ketan Parekh. And, my lord, transactions involving them, my lord, were directed, my lord, by SEBI, my lord, to be examined. Now, my lord, SEBI, of course, carried out, my lord, its own, my lord, proceedings. And, my lord, necessary punishments were, my lord, imposed. Others were given warning, etc. Now, my lord, during the course of, my lord, a SEBI investigation, my lord, and directive, my lord, was issued to the Calcutta Stock Exchange to make inquiries regarding 261 brokers, my lord, who had, my lord, occasion to deal with some of these transactions on the face of, my lord, the records. My lord, my client, my lord, was one of them. My lord, for the purposes of carrying out that inquiry, and I'll show your lordships, my lord, the relevant provisions of, my lord, the Securities Contract Regulation Act, the SEBI Act, and, my lord, the regulations which govern. My lord, an inspection, my lord, was carried out. My lord, an inspection report, it now transpires, was prepared, but none was given to us. And, my lord, our responses, my lord, several queries were put to us. My lord, after a particular date, my lord, there were no more queries. So, my lord, we proceeded on the basis, my lord, that, my lord, all queries, my lord, had been, my lord, answered. My lord, the Securities and Exchange Board of India, my lord, also gave us a clean chit, my lord, which is, my lord, I think far back as, my lord, 2007. My lord, 2003 and 2007. And, my lord, what has happened, my lord, is we, my lord, every broker, my lord, has to have a deposit. My lord, in the meantime, of course, Calcutta Stock Exchange, my lord, is, my lord, went through, my lord, administratorship. And, my lord, SEBI directed its closure as well. My lord, I must tell you, lordships, I'm appearing for Calcutta Stock Exchange there. My lord, to say, my lord, that SEBI direction for closure, my lord, is bad. My lord, that, so, my lord, we've challenged that, my lord.
That's why I asked you, learned friend, whether, I mean, he had his professional remunerations and all.
No, my lord, it's, my lord, it's.
I cannot ask you that.
My lord, this is the oldest, my lord, stock exchange. 7 Lions Range, my lord. Yes. And, my lord, in fact, one of the allegations, my lord, we, my lord, made there, my lord, is to really have, my lord,
The reason why this is happening is, my lord, to my lord, really deprive, my lord, other centers and, my lord, concentrate everything, my lord, in, my lord, Mumbai. My lord, like Securities Appellate Tribunal, my lord, is only in Mumbai. My lord, anywhere else, my lord, it's, my lord, it's not relevant. My lord, at least, my lord, Chennai, my lord, got, my lord, certain additional tribunals. My lord, same tribunals, my lord, are in Chennai. My lord, we've asked for it, my lord, region-wise. My lord, representations have been made. My lord, only, my lord, the south has succeeded, my lord, up to Chennai. My lord, the eastern region, my lord, northern region, my lord, it's not happened. Now, my lord, and western, of course, my lord, as far as SEBI, of course, my lord, it's, my lord, primarily centered, my lord, in the west. So, my lord, this is what it was. And, my lord, we, my lord, have a deposit, my lord, as a broker, my lord, with, my lord, the stock exchange. My lord, with, my lord, all these actions being taken against the stock exchange by SEBI, really, my lord, no business was being transacted here. My lord, we, my lord, wanted to go out because, my lord, we have now, my lord, by and large shifted our terminals, my lord, to the National Stock Exchange. My lord, there was, my lord, inaction on the part of, my lord, the Calcutta Stock Exchange. My lord, 2 writs were filed. A suit was also filed by us, my lord, for refund. My lord, I'll show your lordships, my lord. I don't know if your lordship has been told this. My lord, there was a settlement, my lord, which was agreed that, my lord, we will withdraw all proceedings and they would refund the money. My lord, we go ahead and withdraw, money doesn't come. So, my lord, we file, my lord, another proceeding, not asking for everything. We say, very well, you're looking at all that. But the deposit which I have made with interest has gone up to a sum which is far in excess of the deposit requirements under your regulations. So, reserving our right, my lord, to claim the whole amount, we said all that you can keep is what I'm entitled to deposit, which I'm liable to deposit, not anything more. We moved the writ. Now, my lord, the learned single judge said, when, my lord, the writ was moved, my lord, the stock exchange got up and said, well, there is an investigation pending. So, unless that is concluded, we are not in a position to make any refund. This was about 18 years, my lord, after, my lord, all this is happened. Now, my lord, the learned judge, my lord, disposed of the writ petition by saying within 45 days, you must proceeded on the basis, no affidavits on the first day, proceeded on the basis as if there was an investigation. And, my lord, that, my lord, they should determine it within 45 days. And, my lord, if it is found, my lord, that nothing is due, naturally the money would come to us. My lord, otherwise, my lord, the consequences, my lord, would be different. My lord, we went up, my lord, on appeal, my lord, to that. Ultimately, my lord, the division bench of our court, my lord, set aside that order. But, my lord, made a provision that since 45 days have passed, since that order was passed, in the event there is any decision, it would be open to us, my lord, to challenge it in the writ. So the writ was remanded back with, my lord, this liberty. That is how, my lord, we are before, my lord, your lordships. My lord, this is, my lord, in short, my lord, how, my lord, this, my lord, matter, my lord, comes before your lordships. Now, my lord, may I, my lord, just give your lordships, my lord, a context, my lord, to, my lord, this, the points, my lord, which we wish to, my lord, place before your lordship. Then, my lord, I will, my lord, go, my lord, to, my lord, the list of dates, which are fairly comprehensive because it's a fact-heavy matter, my lord. My lord, first, my lord, is, my lord, at no point of time were we told that there is an investigation being conducted by the Calcutta Stock Exchange on its own, under its rules and bylaws. At no point of time. In other words, because, my lord, those are the rules and bylaws which have been quoted in the impugned order. In other words, my lord, to put it, my lord, more pithily, my lord, in the, or my lord, in, my lord, the constitutional jurisdiction, my lord, there's really no show cause notice. That is a specific case. Second, my lord, is, my lord, we find, my lord, from the order that there is a particular document, my lord, which is being referred to as a show cause notice from the impugned order, which, my lord, I shall show your lordships. It's dated, my lord, kindly just note the date, 4th of March 2004. Now, my lord, we say, assuming this to be the show cause notice, my lord, we have not been told under what provision we are being proceeded against, number one. And number two, my lord, what is, my lord, the consequence, my lord, that we might suffer in the event the case has made out in the show cause notice, my lord, is, my lord, established. So, my lord, the show cause notice, my lord, if it is one, my lord, is also bad. Third, my lord, the show cause notice, my lord, relies, my lord, on, my lord, an inspection report. Now, my lord, the impugned order which has been passed, rather, my lord, rather than the show cause notice, my lord, it is the order, my lord, which refers to an inspection report. Order refers to an inspection report. It's not there in the show cause notice. My lord, the order refers to an inspection report, to which, my lord, there's no reference in the show cause notice. My lord, I was wrong in saying, my lord, that
the other way around.
yes. So, my lord, a document, my lord, which was, my lord, not a part of that particular document of 4th of March 2004, is relied upon, my lord, in passing, my lord, the impugned order.
Naturally, no copy of that was
nothing.
Good.
And, my lord, that's, my lord, an admitted fact. My lord, that itself, my lord, according to us, my lord, vitiates, my lord, the entire decision-making process. Because, my lord, no opportunity, my lord, was given to us, my lord, to, my lord, deal with this. Now, my lord, the so-called document of 4th of March 2004, my lord, which is referred to, my lord, as, my lord, the show cause notice, was responded to by us on 18th of March 2004. Now, my lord, for 18 years or more, my lord, no response. No response at all. Now, my lord, there is a series of cases that if an investigation, and I'll cite them, my lord, if an investigation is continuing, and, my lord, there is a response to the show cause notice, and nothing happens, apropos that investigation, there are cases of 7 years, there are cases of 11 years, there are cases of 37 years, my lord, the investigation, my lord, cannot result in, my lord, any penal consequences. My lord, this is, my lord, one of the, my lord, points, my lord, which we, my lord, seek to urge. Now, my lord, we have also raised, my lord, a point to the effect, my lord, that the impugned order, my lord, has been antedated. My lord, there are very interesting facts here, apropos, my lord, the impugned order. My lord, the impugned order, my lord, just make a note of it because I'll show, my lord. My lord, the learned single judge's order, my lord, was 2nd of February 2022. The impugned order, my lord, was 15th of March 2022. It, my lord, is allegedly sent under a cover of a letter which is dated 16th March, one day, my lord, from, my lord, the date given to the impugned order. Now, on 29th March, my lord, is the division bench order. My lord, matter was going on before the division bench. Nobody made a submission, my lord. The stock exchange was there, that an order has been passed, it's been communicated, nothing. On 2nd April 2022, after the division bench order, my lord, we received, my lord, the impugned order. And, my lord, the date of dispatch, though the letter is dated 16th, my lord, is 1st of April 2022. And my lord, kindly note that this dispatch is after we communicated in writing, my lord, the division bench order on 31st March 2022. My lord, this is a point, my lord, which we have taken.
What happened on 16th of March? The covering letter of that communication.
It's dated 16.
That date is
dated. My lord, 31st we communicate, the order of 29th, 1st April it is dispatched, we received on the 2nd. Because, my lord, if the order itself was being set aside, my lord, that liberty to conclude the investigation and then give the money, my lord, would, because the order is being set aside completely, my lord, by the division bench, and there's no challenge. So, my lord, this is, my lord, how, my lord, they have, my lord, proceeded, my lord, with this. Please. Ask them. Then, my lord, other than inspection report, 2 other sets of documents have been relied upon, my lord, in the impugned order. It comes under the same classification. Material, my lord, relied on, which was not made available to us. My lord, this is, my lord, other unknown documents, my lord, referred to by Calcutta Stock Exchange. It says so in the impugned order. And, my lord, a disciplinary, my lord, sub-action committee meeting of 24th of May 2008, which is not part of the show cause notice. It's a material, my lord, which has been relied on. They are completely absent, not given to us, my lord, at any point of time. Then, my lord, the conclusions, which I'll demonstrate, my lord, to your lordships, of, my lord, wrongdoing, which are there, my lord, in the impugned order, are, my lord, on the face of it, contrary to the records and contrary to law.
Yes.
My lord, I think, my lord, this is, my lord, overall, my lord, and other than, my lord, just one other thing, my lord, the constitution of the board of the Calcutta Stock Exchange, on the date the order was passed, my lord, the board, my lord, could not have convened at all because there was no quorum. My lord, your lordships aware, my lord, under, my lord, the amendments to, my lord, the Securities Contract Regulation Act, my lord, there had to be, my lord, corporatization and demutualization, my lord, of stock exchanges. So, my lord, the, my lord, management and the brokers, my lord, members, my lord, were, my lord, separated so that there would be no conflict. So, my lord, we have, my lord, Calcutta Stock Exchange, my lord, is in fact, my lord, had thought of that long before, my lord, all this had happened. My lord, that's how, my lord, it had arranged its, my lord, affairs. My lord, SEBI regulations required, my lord, what they term as, my lord, public interest directors and shareholder directors. And, my lord, for there to be a quorum, my lord, both had to be present, my lord, in equal number. And then only, my lord, if there was a majority, which, my lord, constituted, my lord, of, my lord, the public interest, my lord, directors, voting, while voting, my lord, only if majority of public interest directors voted, my lord, in favor of a resolution, could it be given effect to. On the given date, when, my lord, the decision, my lord, is taken, my lord, there is no shareholder director, my lord, which is, my lord, apparent, my lord. So there could have been. And, my lord, so, my lord, there was, my lord, on the given date, my lord, no quorum also, my lord, to arrive at the decision. My lord, this is, my lord, in short, my lord, the, my lord, background. Now, my lord, if your lordships kindly take, my lord, the list of dates, I'll go through it very quickly. I'll show your lordships, my lord, छोटा भाई है हाँ जो अच्छा SEBI.
Should we start tomorrow, Mr.?
Yes, ma'am. My lord, only one indulgence. In case I'm not here, my lord, responsibility is his, my lord, to start.
Definitely, yes.
My lord, I'm just making that because, my lord, I was told there was a real dodge yesterday. My lord, I was just outside and then he told me he had a fixed appeal at 3:30.
Now, said my lord in front of my lord in court, I can't my lord now go away anywhere, my lord.
No, my lord, usually I take responsibility, my lord, but now, my lord, it's becoming in private matters, my lord.
Very difficult, yes. Okay.